And Megan Fox here at PJ Media is explaining.
What's tip 4?
Well, don't trust women. I think you just touched on that with your Dancing with the Stars.
You can still love me.
I do. I love you all the time. But our First Amendment rights are huge. They are very important to me. They should be important to everyone. Don't be a public official if you don't want to be filmed, ma'am.
Megan Fox.
Yes.
Hey everybody, good afternoon. I'm Megan Fox. I write with pjmedia.com, and today I am going to be watching this pre-trial hearing for the Waukesha murderers trial, Daryl Brooks versus the state of Wisconsin. Daryl is accused of mowing down a Christmas parade. You remember him. He's being charged with 6 counts of intentional homicide, and he is representing himself. So this is going to be a shit show. This is going to be absolutely ridiculous. And because of that, we have to watch it. So at some point, Fair and Balanced is going to drop in and say hello and hang out for a little bit, which is great because, you know, I've been meaning to get her on here for a while. I know that Nick Ricade is streaming right now too. So yeah. So I'm probably not going to be able to pull many numbers at the moment because Ricade is doing this as well, but that's okay. Because you guys, you know, I love you guys. All right, let's see. Yeah. So he shaved his head. So that's a different look than the look we had from the mugshot. Shall we show you the mugshot? Do you remember his mugshot? It's hold on. Let me see if I can pull it up. Oh Lord. So he's got a different look going on. I guess he doesn't have a lawyer, so there's no one to tell him what to do. But this is what the mugshot looked like. This man ran down senior citizens and children, and you know, during a Christmas parade. And you know, I'm very skeptical about this representing himself stuff because that just sets it up for later on for ineffective counsel, complaint, you know, appeals. And I don't know why I don't know why they allow it. I really don't. Where is Gadfly? He is supposed to be here. Well, he said he would come if he could. He has been working really hard. I guess he's working on some kind of music video or something. So he's been in the studio a lot, but he said if he could come, he would. So we're just waiting for this to get started here. And as you can see, there's nobody behind the Brooks's table except himself, because he's going to be representing himself. And this is, by the way, if I could just give you some advice from a non-lawyer, if you're involved in any kind of legal situation, do not represent yourself. Do not go pro se. It is really, really difficult, and you'll get caught on technicalities every single time. Dobre says, love and respect you, but the Pope is on, so you should demand he stop and come on your stream. That's funny. So I did invite him to come on, but I didn't realize that he was streaming. So obviously he's not going to come on. He's in the middle of his stream. But don't worry. Perhaps we will see Fair and Balanced soon, and I'll invite my sister to come hang out too, in case she wants to come hang out. I mean, I really am concerned about him representing himself for the very reason that an appeal is going to be, you know, he's going to say he can argue ineffective counsel, I guess. I mean, I don't know. Can he do that? Where is the sound? I guess we don't have sound yet. Yeah, always have an attorney, guys. Always get an attorney. Here we go.
CF 1848.
Really low.
May I have the appearance, please?
Boy, they need to fix the microphones.
Leslie Daisy and Zach Witchow, all appearing for the state of Wisconsin.
Sir, state your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative from my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case.
What?
I do not dispute any of the facts in the charging instrument.
What is happening?
Also, Your Honor, I would like to make an offer for my appeal, if I may.
I'll get to that momentarily. The record will reflect that the individual known to this court to be Daryl Brooks is appearing in person in custody. We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues and other legal matters. So he is appearing today in jail attire. He is in custody.
I don't know why he's bent over like that.
And it's my understanding, Mr. Brooks, that you were offered to appear in the suit, but chose to come to court in jail attire, which is fine. We're not in the presence of the jury. I just wanted to make a record of that.
He chose to come in the orange jumpsuit.
I'll be consent or identified by the name that you stated earlier. I want the record to reflect that, if I may.
What?
The record will reflect. Thank you.
He's trying.
All right. I know there was some
How is
filings,
he a
and I want to
third
make
party?
sure the parties have copies of everything.
They should not
Mr.
allow
Brooks, I
someone
know
like
there was
this
an inmate
to represent himself.
communication form filed. I believe
Holy
earlier
shit,
this
Sharon.
morning,
It's already a shit
requesting
show.
6 subpoenas as soon as possible.
I heard he
My staff.
decided to be fashionable today.
Copies were
Uh-huh.
of the subpoena
He's
forms,
also bent over
were
and like hiding
provided
his
to
face from
you.
the
I
judge.
did receive
Good God.
verification that those were hand delivered.
He also doesn't want to be called Daryl Brooks. He wants to go by another name. Is this an announcement of
Did
being
you receive those,
transgender?
sir?
I'm not sure.
I think that's like a sovereign
did not.
citizen thing that they do.
Oh,
We'll provide additional.
I'm still
copies,
learning
but
about
it's
those
my
people.
understanding those were hand delivered.
I can tell you about
To
that
the
lots.
jail,
We should
and
do a
the
whole
jail
show
took
on
care of that in the
sovereigns.
event
Oh.
that
I
the
have
latter
a
part,
lot of
did
information
not
on
take
sovereigns.
place.
Let's do it.
Mr.
By the way,
Brooks,
this
I believe
judge,
you were requesting
kind of a babe.
6
Kind of
subpoena
totally a
forms.
babe.
I'm going to have my clerk print out 10 so that you have ample copies. And when that is done and those are handed to you,
She
I'll
should have
make a
started with her
record
hair
of
up though, so
that.
she could take it down halfway through and shake
Yeah.
it out and make everyone go nuts.
So you know that she's serious too. Be like,
We address
all right, I'm
the
not going to tell you again.
petition form I sent about.
I have a number of issues I need to address, so yes, we'll get to that.
You don't believe that has that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up.
This is such a bad
I'm
idea.
not seeing it in the record yet, so
You know,
I did a F5.
it's a free country to make your own choices. Can't argue that.
Prosecution will receive a copy.
I believe one was printed now for them. It is in the
This poor
record.
judge is going to have so much patience to deal with this
And then
bullshit
I'm
that's
gonna
coming.
print off something as well. I don't know if it was already.
He is the only one in a mask too, and it's inside out, by the way. It's got the white part is on the outside.
I'd like to state for the record and would
Oh, here
like
we
the
go.
record to reflect that I believe that this is an issue that should be addressed at this point before we go
Sir,
any
I'm
further.
preparing to do that. I didn't say I wouldn't do that. So give me a minute. I have some documentation that I'd like to provide to the parties as well. I want to confirm with Attorney Opper that you have now received a copy of that inmate communication form.
Yes, I have one in front of me, Judge. It's dated today's date, October 5, 2022.
22.
Yes, dated.
She's got a great
today, because I
accent.
just
Oh, yeah, she
learned
does.
of the protocol that I would be on as of today.
Copies, one for each party. All right,
I don't
I'm
know
gonna
why he's not
provide,
sitting down or
some-
standing.
a document to the.
Hey,
charge,
standing
it's a
takes
5-page,
work.
Document. It is a document that was forwarded to me at my request by Monica Paz, our clerk of court, after receiving the inmate communication form from Mr. Brooks requesting an adjournment. For the reasons stated in that document, I thought it
I
important
messaged
that we all
Ricada, said
have
we should come
before
on
us
your
the
stream
current
after. We're live
company
too. We should
protocol,
come on live after our fight.
related to COVID-19.
I told him, I said, we're going to beat you in numbers because
So
we're going to
this will
talk
be
about
provided
which
to the parties.
which fight we're going to have. Is it
Fine to,
Jello or is it mud? We're going to have to decide.
Accept
Oh,
that if I don't
Sir,
believe
it
I
will
that
say
be-
we
it's
it
go
will
true.
be
big and we
placed on
start with the
table,
baby
but I
pool
will
and
be
lube.
today, so it's been given to you.
I mean, let's give them a show.
Is verified law. Ground.
Good
Attorney Opper,
Lord.
do acknowledge that the COVID-19 illness reporting protocol was provided.
I respectfully object.
Yes, Judge.
Your Honor,
Oh,
I would like
jeez.
an answer to that question if I may. As I have not consented to or agreed to accept any paperwork that,
Sir, it's been
It's not
provided
okay.
to you. It's
So are you
something
I
I'm
have
gonna
not
consider.
agreed to
You
accept
don't
any
wanna
paperwork.
read
he
it,
says.
you wanna
Making a
disregard it, that's
judicial-
your choice.
That's
are you
not
making
how
a
it works,
judicial
Daryl.
determination that you don't have to answer that?
Ricada says
question
he'll
I
only
just asked
accept
you,
the
Your Honor?
victor.
Mr. Brooks, the COVID-19 protocol has been
I don't know how
placed
to
in
get a
front
hold
you.
of him
It is your
anymore.
Choice whether you want to
I
review
know.
it
You
or
have to text
not.
him. What? Did the stream
So
stop?
my
Oh,
understanding,
okay.
No,
just
she's
from the information
trying to gather her thoughts.
Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings due to learning that he's on a COVID-19 protocol.
Huh?
I don't have any other information than that, sir. But based upon,
Oh no.
and again,
Don't
I
you
did
dare.
grab. I didn't grab. I was provided with the COVID-19 illness reporting
Farron, you can
protocol.
super chat Nick now.
I wanted to make sure that I had the most recent
You need to
Hell
get a
no.
hold of him.
information that
Send him a
at least
super
the
chat.
county of Waukesha
We are way
is
past super chat
operating
level.
under. I also
I brought in that guy so much money 2 weeks
verified
ago.
with court staff
I knew
that
they were
the
going to start
location at
calling
which you are
her
seated
Judge
is
Mommy.
not within 6 feet of any other individual.
I was about
in
to
this
too. They
county.
beat me to it.
He beat me.
Is there any other information you think I should know as I consider your request for an adjournment today?
Yes, I find it hard to believe that you couldn't consult with jail staff to verify the protocol, to verify that I was seen by nurses.
Sir, your mask is
I
on
don't have that
backwards. We don't take you
information, sir. Let me be
seriously.
clear, cannot be provided to me under HIPAA. The only information I have is what you put in the inmate communication form.
It could be verified because I was told when I was brought down here that everybody knew that I was on a COVID protocol. That's why everybody
Because you advised us.
That's why, no, because the jail advised them.
Is this
That's
true?
why
He
they had
threw a
to wear
chair yesterday.
masks
Is that why he doesn't
to
have
bring
one?
me down. That's why
I don't know.
He got kicked out of jury
essentially
selection apparently
on a
for being too
protocol
crazy.
that doesn't
Oh,
allow me
jeez.
out of my cell until my results come back. So I'm not allowed out of my cell at the moment because of the protocol that the
Then how are
nurse
you here?
himself
Yeah.
placed me on, that the jail confirmed. That is very easy information to obtain.
Sir, I
Just-
have
just like-
an attorney for the
excuse me,
county
Your Honor,
here
I
who
don't-
will
I don't wanna-
verify
I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due
I
to
don't-
HIPAA.
I don't want you to think I'm
requirements.
arguing.
So I'm not
But I-
arguing it with you,
I
sir,
know, I
one
just
bit.
want you
Oh,
to know that
God.
I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here we
don't
go. Let me,
consent or
You
let
don't
me,
have to
cut off.
consent.
right when I'm trying
all right,
to
I'm just
provide
gonna
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, Due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request,
She has to
because the
talk to him
jail
like he's a
has
fifth
not
grader.
provided me with
Mhm.
any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me if you so choose.
That is incorrect, because just yesterday you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste, fatigue, and I have to wait
That's all
for the
she asked
results
you.
of
Do
my
you have
test.
symptoms and
Until then,
stuff?
I am on a protocol
What is
which
wrong with
restricts
him?
me
This
to
guy,
my
man.
cell. That is very easy information to obtain, and I find it very hard that Your Honor cannot obtain that information, but can obtain a way to communicate with jail staff.
Just Laura wants to
when
know
there's
who
a
does it
witness
better,
list involved.
Brooks or Bredehoft?
We're talking about
Ooh.
someone's health that can affect not just you, but anybody else, not
I would
just
kill for Elaine to be
officers, but
back.
also inmates. We're talking about health when we're talking about safety. That
I
has
mean,
a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. I'm that was the last thing I was hoping I would
He
be
doesn't
told
know how to
today,
wear a
Your Honor.
mask either.
So I'm afraid right now.
I think it's upside down too, Farron.
I'm
Look.
not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered, and that's why I'm on the
Yes,
protocol.
perhaps he
as
should
we
have an
speak.
attorney.
Are you
Yes.
willing to discuss with me what tests were done?
I
Again,
don't-
I cannot obtain that
I don't.
information
I'm
on
not
my
a.
own.
I'm
Farron,
not a
ignore the
nurse,
trolls.
Your Honor. I don't know.
I
the
loved
no,
the
I
show.
test. I don't. Like
I
I
loved
said,
the show.
I've never had this
Let me
happen.
clarify that.
Well,
That,
it's-
that was a
we'll talk
pretty
after.
ambiguous question. So,
I like to
you
respond sometimes,
reported
though.
symptoms.
And Michael Palmer
is-
and I have
is-
a
that's what you're telling
spicy
me, right?
relationship.
Correct.
Oh, really?
And you're saying some
Mhm.
tests were done?
Oh yeah.
I mean, that it's obvious. I mean, why can't
Who
it be
hasn't gotten
verified
wasted on
with
a
the
stream
nurse?
I
with
have
Nick?
to verify it with you. The nurse will not
All of
provide
us
me with this
have.
information.
But the jail can, because they control the movement. They
Um,
control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the
It's
moment.
not. But I'm saying, how can I tell
Look at her
you?
face.
How can
It's-
I answer
She was like,
what you're asking me? It doesn't make
Well, I
sense.
love how he looks at
We
her like
all
she's the
understand
idiot.
that the jail itself controls the movement of the inmates. That's
so
common
why are you
sense, Your
here
Honor.
if you're
I'm
under
not here
quarantine?
to talk
I
about
can't-
inmate
I can't
movement
just-
at the
I can't
moment. What
just
I'm
walk to
asking
the
you is,
HSU.
do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
No, that's not how it goes,
No,
sir.
nurse-
What
Nurses-
type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
And it was
Do you know
positive
when
or
the
negative?
results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to
20-minute
be at
discussion
least
because he doesn't
on
understand
this
HIPAA.
protocol
Exactly.
until the results come back, which
Were you-
he said the earliest would be Friday.
Were you offered
Christ
a rapid
almighty.
test?
They said they do not do the rapid test.
So you weren't offered
Sir.
a rapid test?
They said they don't do them.
I get 3 rapid tests a day
If
from
one can
school in my
be
kids'
obtained, are you
backpacks.
willing to
Yeah.
submit to a rapid test?
I'm not
I
willing to
highly
submit to
doubt
anything
he
right
doesn't.
now
He
until
didn't get
we
a rapid
take care of
test.
the issues that's at hand. I mean, I've already been placed on the protocol. Frankly, I'm very afraid right now because
Did-
I don't know what's
Did
going
the
on.
dog eat your COVID
this
test
is
too?
new
Like,
to me.
that's where we're
Like I
at.
said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021.
So why are you so afraid?
And so for this to just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor.
He's going to prison
That's
for
the
life,
reason
even
why
with
I
a lawyer,
submitted
though, too.
the
You're
ICF
afraid of
for the
COVID,
adjournment.
and
I was
people are
thinking
afraid
at
of you
least
being
until
out
I
in the
can get the
fucking
results
streets.
at bare minimum.
Exactly.
I
Like,
don't think I'm asking something that's
Sir,
impossible for
if
Your
I
Honor
can
to
make
grant.
arrangements to have a rapid test brought to you and administered, are you willing to
Right
submit to
now.
that
Let's
test?
Yeah,
do the
right
rapid
now.
test right
Why
now.
not?
Not at this time.
Oh,
Why can't I get the results of the test I already took?
take
But you're telling me you're scared?
It'll take
You're
3
Yes,
minutes.
I am.
But you don't
very.
want to take a test that might
I
tell you
took
today?
I took the
Ex-
test that
3
that
minutes.
he gave me.
And
if
you're
he
telling
felt-
me that test result won't
Look
be
at they're
available to you
laughing
until
at the
least
other at the
Friday.
At least Friday,
prosecution.
that's what I was
So
told.
tomorrow.
they're like, I
would
feel like
be
I'm back
placed
in
on
law
this
school.
protocol
Yes,
until
Listerin,
the
he thinks he
results
has
came back.
COVID.
The earliest that the
Sort of.
results will be back would be Friday.
I don't
So
think he
that
actually
sounds
thinks
like,
this.
to me, I think that's what they call a PCR test.
I
Right.
have no idea, Your Honor. I
Okay.
have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never
It's called a
had COVID.
PCR
I don't
test.
know the test names. I don't know what they call them.
I'm generally familiar.
This woman has so
with
much
some of the
patience.
testing for COVID. There are tests that can be what we call rapid tests, or what are called rapid tests, that are available.
Oh God.
Let me talk to
and
you
then
like you're
there's,
5.
These other tests, which take a few days. It's
We have now
again, I'm
turned
not
my
a
courtroom
scientist, but I think
into
the
a
general
COVID educational
belief would be
session.
sometimes the
Perhaps
rapid
I'll
tests
show
are
you in
accurate,
pictures.
Sometimes they're not. Sometimes people test
You
negative.
should order
when
the
they're really
bailiff to just
positive.
go
It
get the
kinda
rapid
depends on the
tests that are sitting in the break room
circumstances,
and
Yeah.
it's
and
my
give him
understanding
one.
a positive test would be pretty accurate. And then there's other tests that take a few days for the results to come back. It really depends on the lab that's being utilized, etc. I'm asking you once again, if a rapid test
Yeah, he's
can
trying
be
to push it back.
obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
Right
I was
here,
told-
right
I can
now.
only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to even test me for this? What is this about?
Well,
I had
did
a
you report
lieutenant.
symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need? What's going on with this? Why is this? Why is this? Why is that? Because I didn't understand.
Yeah, we're asking those questions
Immediately
too.
in my head, I started to get afraid when they said they had to even test for.
Yeah, I like
COVID.
this idea.
Well, were you
Move everyone
reporting,
6 feet away from
being
him and
sick
continue
and
on,
symptoms
please.
prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue.
Oh
With
Lord.
me feeling very fatigued, and I said, "Man, I don't know if it's just me being tired."
Now
or
this is turning into a doctor's appointment.
That's what I initially thought it was. Maybe I'm just a little exhausted, but I said no.
Jesus.
Anybody knows their body.
Has
I
he
said
been tested for
something. It's
monkeypox?
got to be
'Cause
something more
something
because
tells
I'm
me he may
really,
need that too.
I don't even have an appetite. Then when I'm trying to eat, I can't
Again.
taste anything. That's what's it. Okay, now I
You know who
need to
can't taste anything?
the,
The 10
medical,
people you
When
killed.
did you report these symptoms to
That's
the
right.
medical people or to
The senior
even just a
citizens and the
correctional
children you
officer?
ran over. They can't
Yeah.
taste anything
few
anymore,
days
Daryl.
ago.
Nobody cares,
A few days
Daryl,
ago,
if you have COVID.
over the weekend, is
No
when I
one
started to notice
cares.
the fatigue. So I was telling
That's the
officers
least
About
of
your
your problems.
fatigue.
I'd rather
I don't
have
know if it's
COVID
just I'm
than
tired.
drop the
When
soap,
did you
sir.
Usually I don't
Jeez.
just jump the gun and say something's wrong, because
Jump the
it may
gun.
just be it could be anything. So
When did you report the loss of taste?
I reported the loss of taste last night.
And was it after that they told you they wanted to test you?
No, they didn't tell me till this morning that they wanted to test me.
Golden Girl, his
What other
diagnosis is that he's an
symptoms, are
asshole.
you
That's the diagnosis. Daryl Brooks is an asshole.
reporting
Mhm.
at this time?
That was it so far, just the fatigue and the
Carly,
loss of
good
taste.
point. Eating jail food, loss of taste might be a blessing.
which is the reason why I was told that I had to take the test.
If I'm
Which
this
I was
judge, I'm
told at that
literally
time
going to just
also
order the bailiff to go get the
that the
rapid test and
earliest
administer
my
it right
results
now.
would be
Shove it up
back
his
would be
nose.
Friday.
He's in custody. He has no
And
rights.
you said at this point, you're not willing to take a rapid test.
Not many
Well, they said
anyway.
this is the test that they do. The nurse was very clear in what he was telling me when he told me how the test, because like I said, there was a lieutenant and 2 officers right there while the whole thing was going on.
I understand all of that. I have a very specific question to
I
you,
was
sir,
asking
though.
them questions, and he specifically told me that this jail, this is the test that they do. They do not do rapid tests. I didn't even ask about the test because I know nothing about the test. This is what I was told. And after he told me that, I said, okay, fine, just do the test and I'll just sit on the protocol, because at first when he told me, you're going to have to be on the protocol where you're isolated.
This is going to go on forever.
I said,
Why doesn't
okay,
she
fine,
just say no?
Just do the test. I'd rather you do the test and
that's
make
where
sure
we're
that
at
I'm
this
healthy
point.
I would have stopped this already.
than to just
She has
refuse
more
the test and
patience
just
than
say,
I
I'll
do.
just wait for it.
But see, she has to, because this guy, wow, that was a loud truck.
And that's
that
what
just
I
went
was.
by.
Well, I was like, are they bombing the courtroom?
It was on my end.
Got it.
The protocol, which is
This
called
guy,
isolation,
because
where
he's
I'm not allowed out of my
representing
cell.
himself, she has to be so careful, because if his
Anything
rights
could be
are determined,
unconstitutional.
right, are to be
Anything
violated,
else,
that's
sir, you
it.
think I need to know about this issue as I consider
It's like
your
I got a plug in my
request?
mouse.
No, at this time, I'm just telling you what I know. Multiple officers were there. They can tell you the same thing that I'm telling you now. Like I said, a lieutenant.
Let's get the officers
Lieutenant
on the phone
Chamberlain
right
was
now.
there. 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's available for testing?
Absolutely not.
Given any information about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the mental health medical pod as it is. I'm
So no information.
So they're letting a mental patient
there's
be
like
his
either
own
a
attorney.
lockdown or
That's what I just learned.
some type of a restriction due to any like
This is a bad
concern
idea.
over COVID at this time.
I would never have that information, because like
The
I said,
jury is
I'm
already
limited
seated,
in the pod
Curly.
that I'm in. I don't have
This is
no
pre-trial.
interaction with any other inmates.
Jury was seated yesterday.
And my interaction with staff is pretty limited.
All right, thank you. I appreciate that additional information. I know, sir, what I've provided to you is generally the
Okay, sorry.
for
He
employees.
apparently he
I
passed
fully
4 mental
recognize that the
evaluations.
jail may have different protocols just because of it being in a correctional facility, and inmates are, of course, or can be very close to one another. And so I don't want to presume that this is exactly what they follow. And so I'd like for them to tell me what their protocols are as I consider this request. At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And
So we may
I
proceed.
believe that provides ample protection for the other people in this courtroom. As I consider this request, you've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding of the protocols, and despite you reporting fatigue, I know I don't know if you're standing or sitting on the chair. I can't quite tell.
Oh, he does have a chair.
But maybe leaning over the table.
Sit down, sir.
Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks, I can advise the court
Mm.
as an officer of the court and as an offer of proof that he is.
How could
Mr.
that,
Brooks, did
how could
you
that
hear
even,
Attorney Opper interrupt you when you were talking?
well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd
That's
encourage you to use
that is
paper and a
ridiculous, Your
pen
Honor.
She's
to
gonna
write
need
down.
more
That's
Xanax
the rules of
soon.
decorum in the courtroom,
Like,
sir.
I
We
get representing
generally
yourself, but I
avoid
think we really need to consider
interrupting
that now.
one another.
Like,
So that number one, the
no.
record can be
That-
clear.
She's gonna have to do
and
this the
perhaps
entire
most
trial.
importantly, because that is
Oh, this is gonna go on forever.
a sign that we all understand that this is a place of dignity.
I don't know why
it's
she
a
gives
place of
me,
respect.
like,
It demonstrates.
I don't mean this in any bad way,
that,
but like a prettier Monica
frankly, a
Lewinsky.
willingness on the
Oh, she does look like
participants
You know?
Monica.
to
She reminds me of Monica Lewinsky.
conduct themselves.
Welcome to our stream,
appropriately.
folks.
It avoids
She
creating
totally
disorder
does.
or
Right? I can't
disruption.
unsee it.
So
Me
I will give
either,
you an
now that you've said
opportunity
it.
to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Judge Lewinsky.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back. This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also, I believe she would be able to provide information if the court ordered her to do so. I believe that even if he is on COVID protocol, it will have zero impact on his ability to prepare for this case. As we've learned
Yeah, you
already,
good, boo.
and I'm prepared to make a further record, he has all of his discovery materials within the confines of his jail cell. He has a tablet made available to him in the confines of his own jail
New
cell.
ticker.
And he has the ability to use a conference room in his pod. I don't believe the COVID protocol would interfere with his ability to access that conference room whatsoever. But again, I could verify that with the jail administrator if the court thinks that's an appropriate fact. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to...
Speaking of hair, that prosecutor needs something
said
done with
an
her
opportunity
hair.
momentarily.
No,
You
I
need to say
respectfully
quiet.
Pretty
object to
bad.
that because that has no merit.
Go to the hairdresser,
Brooks,
ma'am.
it's
You're on
not your
television.
time
No,
to speak.
no, I respectfully object. I never reported saying what day. I never said a day. And if she's saying she has
Camilla.
jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide proof of that?
All right, Mr. Brooks, I've given you a little
Just
bit of
like-
leeway.
Let's play the
because
phone calls
we are
from the
outside
jail
the
cell.
presence
Waived
of the
something.
jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in fact
No, I think you did waive your HIPAA privileges, sir. You just told
COVID-19.
everyone
How
about
can
your
that be a
medical
delay
condition. That's how
If that
HIPAA
was
works.
a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
Oh, God.
All right, Mr.
Is
Brooks,
there no-
I've
is there
given.
no
Can you
Mr.
imagine
Brooks,
being on this
I'm
jury?
gonna
I was
warn
just
you
gonna
now that
say,
you have interrupted
folks, you're gonna have to block
Holy
out 6
fuck.
months.
Holy
you interrupted
fuck.
Attorney
I
The
have
Opper
to-
jurors
I
are
have
going to
to
be
be
so
able to speak
mad.
up,
You're
Your
now
Honor.
interrupting.
I'm already
me
angry.
yet
We're
again.
only, how many minutes?
I-
34
we
minutes into
all
this.
We're polite and had you
That
provide
was not
information.
polite. That was
That's
abuse.
the least the
that was
third
abuse.
interruption
This
of this
is a
court.
deleted
That was
scene
Yeah.
from
abuse by the
Idiocracy.
prosecution. That was abuse.
Mr. Brooks, let me finish.
No, because that's
So he's outright refusing to listen.
I would
He's
not sit
outright
here.
talking over me.
I didn't
at
She's
the
got to put it in the
moment.
record.
Mr. Brooks, we are at
I'm
the
not
point
gonna.
yet
I'm
again
not gonna.
Charge.
I'm not
where
gonna
I
sit.
will put you in the other courtroom because
And
you
I
are
don't
not
consent.
able.
I don't
Uh-huh.
consent to being removed.
A
I have
moment
not
of silence
waived the
for the
right
jury,
to be present,
please.
and I don't agree with that.
Mr. Brooks,
Does the
I
record
have
reflect?
provided you on multiple occasions and it's should be in front of you.
No,
and
I
if
don't.
not,
I don't acknowledge that.
If we play an objection
I haven't
drinking
agreed
game,
you
with
have
Farron
been
and I
advised
will
on
both
multiple
be
occasions that
plastered
you need
in
to
a
abide
matter
by
of
the standards of courtesy
a half an
Minutes.
hour.
the courts of Wisconsin. Because you are a litigant, you're both a named defendant. You are now acting as your own attorney by
I'm not a named
representing
defendant.
Welcome to
yourself.
Costco. I love you.
That all of the
The
rules
state
of courtesy and
put on
decorum
their
apply
complaint.
to
I don't
you.
recognize
He's
that name,
still
Your Honor.
talking.
Sir,
Farron.
this is not a
62.02
Wendy's. This is a courtroom.
Details many of the requirements for courtesy and decorum. I've referenced a couple of them on multiple occasions, including that sub 1 sub F of 62.02, that proper conduct and attire is expected within the courthouse, and where possible, individuals, including yourself, right, are to refrain from creating disorder and disruption. Sub H, you're supposed to conduct yourself in a manner which demonstrates sensitivity to the necessity of preserving decorum and integrity of the judicial process. You have been advised multiple times, sir, of the expectation that this court has that you conduct yourself in a civil manner. You've been advised multiple times that this court will not tolerate disruptions, interruptions, that when you do that, you run the risk of forfeiting your right to be present in the courtroom. As you know, I have available the courtroom next door that's connected to the holding area. It is connected by audio and visual means. It provides you an opportunity to meaningfully participate by also giving the court the opportunity to control the decorum, to control the disruptive behavior, because primarily your disruptive behavior
She needs
is
to put like a
repeated
shock collar on him
interruptions of this court,
so that
talking
she can
over
hit like my
this
dog's
court and
collar.
talking
She
over
can hit it
the
every time you do
prosecutor. I
this.
appreciate that you have not
Oh, yeah.
interrupted me for quite some time. So at this point, though, I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audiovisual means.
Where we can mute you.
At this time, I would like to hear
Yep.
from the court administrator,
can turn your
especially as it
microphone
relates
off.
to the protocol.
Oh, God.
Did I say the court administrator?
Yes, that's all right.
That's okay. We're in court, and I would like to hear from the jail administrator. Thank you very much.
Yeah,
Just
bring
to
in
get
the
some
guys
general
from the jail.
information, and perhaps even some specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all
Ooh,
of this information.
Shawnette's
with either the
making
lieutenant or
stew.
others who are
I need to know
Ooh.
what kind.
So I believe we
Sounds like
have,
an all-day affair.
Angela Wallenhaupt here, if she would come up to the witness stand.
Your Honor, and if I don't want to mix issues, but the inmate communication form from September 28th.
I want to give her a
also Still
makeover.
needs to be addressed by the
Mhm.
court, and I think the jail administrator may have some information relevant to that issue as well.
All right, thank you. I
Please.
have a list of a bunch of things I want to go over, and I'm gonna,
She just needs some layers so that it's not so heavy
She
on the
has
bottom.
curly hair and she's wearing it like a frizz
Are we
ball. Like
addressing
I could
the
help her with
issue at
that.
hand now,
we are.
or are we addressing something
Don't,
from
if you have
September?
curly hair,
Well, I
embrace
will
the
get to
curls, man.
September
Don't brush it out.
inmate
She's using a
communication
brush
form,
on that
at some
mop.
point during this hearing, but
Don't
right
do
now I'm
that.
addressing The most recent.
If you want the
inmate
law, go to
communication
Ricada.
form
If you
that,
want look
indicates
advice
Hair
5,
tips
and how to
makeup
handle
tips.
yourself, that's what this
Mr.
chat's for.
That's what
request
this is
adjournment.
for.
So I'll have you sworn in. I'll just do it. Raise your right hand. Do you solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Ooh, Shawnette's
Thank
making
you.
a slow cooked roast with potatoes and carrots. Sounds fantastic.
Ooh.
Would you
Okay,
please
so
state your
this is
first
a
and last
witness.
names for the record?
Angela Wallenhop.
Would you spell your
I
last
think she's
name?
the jail administrator.
WOLLENHAUPT.
And
Thank you.
this still is not in front of the jury,
Your,
No.
If you could please
which is
advise us on
later,
the record again
not
of
today.
your
which is an atrocity, or luckily for them.
job title and responsibilities.
Yeah.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the
This is a
division in charge of
This is a funny
all
idea.
staff and inmate issues.
Oh, for sure. Everybody
She's
wants
game.
law. Everybody wants Law and Lumber and I to go on a date. And I'm like, I don't
Could you
think.
provide
Oh,
information
I feel like I'm
Rob's
like
to
I
the
feel like
court
I'm too
on
much for him.
the general
Is he
COVID
single?
protocol,
Yeah,
within the jail?
at least I think so.
It's fantastic.
Judge,
But
I
he's
would
such a
prefer
sweet guy.
not speak to the operational considerations with that. I can speak to the fact that there are different protocols that are put on people for different medical or management reasons, which may have modifications to them. I can speak to the protocol Mr. Brooks has placed on that it won't affect the area he is living in, nor access to areas that are not other inmate occupied.
That seems fair. I don't want to certainly put all of your operations on display. That's not necessary. But if you could speak to the specifics as it relates to Mr. Brooks's current situation.
So he would remain in his current cell housing location. He would have access to a conference room if he needed it, access to a telephone. And we would be able to, it's a safety security measure for him as well as our staff. And we can safely produce him for court.
So, no delay for you, Daryl.
When I hear the phrase being on a protocol, that to me could have more than one reason. Someone could have been exposed, someone could have tested, or someone could have reported symptoms that required testing. Would I be mistaken in any of those beliefs?
You are correct, Judge.
Would there be any other reasons for someone to be placed on a protocol, a COVID-19 protocol within the Waukesha County Jail?
No.
And would you tell me which one of those three options has prompted the COVID protocol for Mr. Brooks?
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is?
Yes,
Based
however,
on information provided to you.
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me
course
to
not.
speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation to verify the information you provided. Is that still correct?
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody else in the jail. I'm not speaking about.
Oh God, that wasn't the question,
everybody's
Daryl.
situation is different.
Right. And I'm specifically referring to your situation.
Well, the question was asked in how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Oh my God, we're still
Right.
on
I'd like
when
to
you took the
verify the
fucking
information
test.
that you're providing to me regarding what was reported by you, what tests
Oh God.
or tests were administered, and why you're on the protocol with the jail administrator.
Of course, his rap
First
sheet
of
is
all, do you
50 pages
understand what I
long.
wanna ask
People
her
do
about?
not just
No, I
mow
do not
down
understand.
entire
Did you hear
parades
what
full
I
of
said
people
just
with
now?
no prior history
understand.
of criminal activity.
But did you hear what I said?
But because we can't keep
I
anyone
think
in
she would
jail
probably be
anymore,
the wrong person
we get
was
this.
asking because she wasn't present.
You must understand then what I'm saying if you think she's not the person who would provide that
No, I don't
information.
understand.
So
I do.
If I ever got in an argument like this with my
No, I do not
parents,
understand.
I would be crucified.
I took his
Let
statements
alone a
earlier.
judge.
I realize
Right?
you don't have a written.
So like I
waiver. It
don't
has
get
to be,
like what
a
was his
verbal
upbringing
waiver
besides
of any,
like
privacy rights
don't know.
under HIPAA.
Probably
and I'm directing you to
raised
answer
on the
question.
streets by gang members, most likely.
Yeah. At 34 years old, if I backtalk my mom, she has every right, she says, in this democracy to slap the shit out of me.
As I said before, I have not reviewed the medical record. It is my
And she
understanding.
does.
he
My
was
dad would just
administered a
say,
test. He was
if you say
also
another
offered
word,
another test,
you'll regret
to
it.
which he refused.
And it would be over.
My mom would say that. My dad would just look
Do
at
you have
us and
any
be like,
information
you're
regarding
an
whether
idiot.
this
And like
other
our dad
test
saying you're an idiot,
would
it's
have
like,
been a rapid test?
maybe I
You
am.
have one sister. How
Do
many
you
how many
have those
siblings do you
tests
have?
available in the
6.
facility?
I'm one of
Oh
6.
my
offered to
God.
individuals?
Mhm.
I have one available right now.
How many boys? How many girls? Oh, she's got a COVID test available right now, she said.
Yes. 3 boys, 3 girls.
Wow.
Of me or of the witness?
That's huge. It's a lot of kids.
Go ahead, you can ask a question.
But you learn to get along with everybody.
If there
And you
were
learn to shut up.
different types of tests available, why wasn't I administered the correct test when I first was tested? Why would essentially I would be asked to take a test, take that test, then turn around again and be told to take a whole nother test?
Oh my God. That's what people did all through
That's
COVID.
almost like
Yeah.
some type of ploy.
Sir, were you not here
some
during
type of
COVID?
scheme.
Were you not aware?
Why?
Sir, what's the question?
I asked the question, why would I not be given the correct test from the get-go instead of having to take 2 tests? If I've already taken one test,
You have to give her an opportunity to answer.
She has to
You gotta
answer it.
Ask one question
Ask the
at a
question
time.
and then
I
shut
just
up.
asked the question.
Can she answer it then? Do you want her to answer it?
This
I
bitch is like,
presume
I'm
you do
about to
since
light
asked
you
the
up.
question, so you need to stop talking so that she can answer it, okay?
Limit your abuse, Your Honor.
I'm sorry?
I don't appreciate being talked to that way. Your
He
Honor.
just said, limit your abuse, Your Honor.
objection is noted. Go ahead and answer.
Judge, I would
I
prefer
don't like-
not to answer that question. He states the wrong test. I don't know what he's speaking of. I have not reviewed the medical record with what test was administered, so I would prefer not to answer that question.
All right, fair enough.
I did not say the wrong test. I said
Why
2
don't you let her
tests.
look at the record
If it
so
was-
she knows?
Why would I need to take 2 tests for the same symptom?
Oh, God.
To relevance and beyond the scope of this witness's knowledge, and it also assumes a fact, not an evidence.
All right, so,
Oh,
I'll
no, the porn
sustain
bot is
objection.
back.
Ooh, hey,
I'll
Bill.
give the
Do I
both
have any,
parties an opportunity
mods
to
in the
ask
chat
questions of this
at the
witness,
moment?
since it's
Can you take
Mr.
care of that,
Brooks's
please?
request.
Mm.
I know do you have any other questions for Jail Administrator Wallen Hopped on this issue at this time?
I don't think I was clear, or I didn't have clarity on the answer to that question. Essentially, what I'm asking is,
Thank you, Shawnette.
why would I need to take 2 tests for the same thing? It shouldn't. If I'm taking a COVID test, why would I need to take another one?
Oh, God.
I'm going to object as to lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
Oh, they're just going to keep letting this guy have questions.
I still don't have clarity on that, Your Honor. I'm baffled.
I'm baffled.
Do you have another question? A different question?
Would it be any way to verify why I would need to take 2 tests for the same symptoms?
I'm not sure I understand the question, sir. I think
I'm referring to the nurse who administered the test.
the nurse isn't here, though. This is Jail Administrator Wallen Hopped.
And that's why it's hard for me to wrap my head around why
He's
Ms.
pretending not to
Wallenhoff would be
understand
called
this.
to
It's not that he
testify
doesn't
when she was
understand
not
it. He's
present.
just trying to make this go on as
think
long
the
as
wrong
possible.
person
He's
to
trying to
testify.
stall.
Do you have any other
Because
questions
the
for
reason
her?
why I say
I understand
that-
what you're saying. Do you have any other questions
Dude,
for her, though?
you're in
Are you sure
jail.
you
You
wrapping
have
your head
literally
around what I'm
nothing else to
saying,
do.
Your Honor?
Take all the
Do you
tests.
have any other questions for this witness?
To your knowledge,
Stop.
you just said that you have a rapid test available right now. When did that become available? Because I was told otherwise.
I know there is a rapid test available right now. As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Objection, relevance.
Oh, good God.
If she
Farron,
knows, she may answer.
did you see
I
this
do not know the
picture
answer to
that
I
Taylor
have not
Lorenz
reviewed
put
the
up on
medical
her
record, jail
Instagram?
contracts with the medical
Did you see
provider.
this?
No.
Do you see the
Thank
problem
you.
here with
Next
this
question,
picture?
if you have one.
This is Taylor Lorenz,
So
who is
there
severely
are more than
immunocompromised,
one
she
type
says.
of
Who's
COVID
wearing
test
a mask in
administered
this
by this jail.
picture? Just to help.
Again, the jail contracts, Judge, I prefer
What is
not
she
to answer that. The jail
immunocompromised
contracts
with?
medical provider.
Idiocy?
I do not direct
She
testing,
claims these things,
for medical
but
conditions.
no one really knows.
That would be our
I just
medical
thought this was the
contract.
funniest picture I ever saw. That
I
poor
believe the
security
record's
guy's face. Oh
clear
my
that
God.
A rapid
I
test
can't stand
was
her.
offered. It was declined by Mr. Brooks. The record's also clear that
I
he did
object to that,
submit.
Your Honor.
He did submit to a test, but this witness is not able to answer whether that was a rapid or not, given
Here's another
her
one. Only the help has to wear the
role
masks around
in
Taylor.
the Waukesha County
You know, she's like
Jail as the
43.
administrator and
I
not
think
in
she's
charge of
78.
medical. I will find she does not need to answer that
Well.
question because it's outside her
Oh,
scope.
God.
And to further answer it,
I can't stand her, though.
might be speculative.
I know, me
So,
too.
do you have another question?
She's
So
having
would-
quite a
would it be
moment,
fair
though.
to say-
Hollywood wants
you
her
just
for
said
every
it would be
documentary.
speculative, so would it be fair to say that it'd be
Well, she is
speculative
represented
that
by UTA
the
Talent
second test
Oh, is she now?
would be a
or
rapid
United
test?
Talent Agency. Yeah.
Of
Mhm.
course she is. Hmm.
Which
Just shove
will
a
make
swab up his nose already.
determination on
We
your
could have been
motion
done with
after
this
all
an
of
hour
the
ago.
evidence
Mhm.
and testimony on
Rapid
this
tests
issue
take
is
5
received.
minutes.
Is that an
I
answer,
can't
Your Honor?
answer that question at this
Well,
time,
I'm
sir.
asking it of Ms. Wallenhoff. Is it because you just said it would be speculative?
Well, you were looking at me when you said that.
Well,
So are you? And I'm not going to answer that question. I'm not a witness in this.
The
I
reason
make
why I
the
was-
determination
the reason why I was
ultimately.
looking at Your Honor is because
Do you have another question
I'm
for
still trying to
Jail
figure out
Administrator
how-
Wallenhaupt?
I thought testimony was supposed to be the prosecution and the defense's time to,
Oh my
to ask
Do
God.
you have another question? Otherwise, I'm going to ask the state if they have any more for this witness.
Oh,
I asked the
God.
question, would it be fair to say that it's speculative about what the second test actually was?
Mr. Brooks, I don't understand your question.
What isn't to understand about it? If you were offered a test,
Objection, relevance.
no, it's a question.
Hold on.
I'm
You're
getting
asking
I'm
a
going somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might.
Objection, hearsay. Oh my God, I don't have a case.
It's very logical.
Objection.
If you were offered a test and you took it,
I
why
love
would
that
you
song, by
need
the
to
way.
essentially take another
I know.
test that could
I
have
best.
stopped and I was like,
done
I know, I saw you.
right from the beginning. If there would be any issues, if there would be
Right, Mr. Brooks, it's not relevant
Again
what
with
she
the
would
loud
do.
motors
so that's
today.
essentially an
What is
argumentative
happening?
Okay,
question,
so why
and
would
it's
I
not
do it?
relevant. So
why would
sit
I
down.
do it then?
You're done
Sit
asking
down.
questions because you've
So
now
is that
asked.
a judicial determination?
I haven't made a judicial
Yeah,
determination.
sit
yet.
down
Go
and
ahead,
shut
Attorney
up. That's
Opper.
my
Bench by
judicial
being able to-
determination.
you can tell he has a
Mr.
lot of
Brooks?
priors because he
Mr.
does know
Brooks,
the lingo.
Here's your warning.
Oh
I'm giving
God.
Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you
I'm gonna
interrupt her,
count
you
to
will be
3.
removed to the next courtroom.
I don't consent to being removed to the next courtroom. I don't consent to even being at these proceedings if I'm not able to put on a proper defense, which is my constitutional
Oh,
right
God,
to be
here
able
we
to
go.
do so. I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to
Ms.
an
Wallenhoff,
estoppel.
although Mr. Brooks is under a COVID protocol, is he still allowed to review his discovery materials in his jail cell?
Yes.
Jay, for relevancy.
To your knowledge, are those materials?
He's objecting again.
I'm sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay.
I object to
Is
that,
he
Your-
still
I object
able?
to that, Your Honor.
No shit.
I'm
You
not
do?
allowed to
Her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after
You can
she is
object
done
to
testifying,
answers.
I will give you that opportunity.
Will she?
Your
will she be able
objection
to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
Yeah.
You have not, Your Honor. You haven't. No.
Shut
Attorney
up.
to Attorney Opper, it is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected
And-
when I was asked.
Right, and when the court rules on an objection, usually the party who objects stays
God,
silent.
this whole thing is just going to be her explaining
rule on
basic
the
court rules to
objection.
him over and
The
over again.
parties don't debate
Yeah,
the
you
ruling.
can't
It's
keep
noted
objecting.
for appeal. And then we
I would-
move on.
Then I would like to put you on notice that I will be appealing that judicial.
We are so
decision.
scared.
Next question, Attorney
Oh
Opper.
Lord.
The judicial determination.
Ms. Molenhop, while on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Computer.
And nothing
She's-
about the
her
protocol
accent
would
is
restrict his
fantastic.
access to any of those materials. Is that correct?
Uh-huh.
Correct, ma'am. And
Wisconsin.
you've indicated
I
previously.
object to that respectfully, Your Honor.
So an objection goes to whether there's lots of rules of evidence that apply. But if you're objecting to her answer, that's a different thing. You can argue the meaning of that later. Okay,
not
the
the
objection. But then you have to say objection before she answers. You objected after she answered.
Didn't answer the last
The
question.
objection
God.
is noted. It's overruled. Her answer may stand.
Fear in your face.
Swollen up, you're aware that there has been digital
I mean,
discovery made available to
take
Mr.
the L.
Brooks for
Take
him
the
to
L.
view in the Waukesha County Jail,
I
correct?
respectfully object to that.
Overruled.
I respectfully
Overruled.
overruled.
Now
He
you're
would
getting it. Now
view
you're
that
getting it.
Digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled. We know.
Overruled. You may answer.
Correct, ma'am.
And
So you're gonna
the
overrule
proto-
everything, Your Honor?
Yes. Yes,
That's
she
how it
will.
works.
You have got to stop. It's fine if you object. I will rule on it as I deem appropriate under
You
the
have
rules of
got to
evidence.
stop.
Which, by the way, I provided a copy for you. See that big book over there?
Oh,
It has the
she
criminal
is losing her
statutes.
patience
It has
now.
the traffic code. It
I
has the
don't
rules
see
of
it.
You
evidence.
tell
Yeah,
him, Judge
smart-ass.
Mommy.
on your table. It's
That-
behind
Smart
the
ass.
microphone, and it's there. I've provided it to you as a courtesy so that you have that available
Oh my
to you.
God.
Anything to me.
Right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
Good.
I provided
Take him away.
ample opportunity for
never-
Mr.
Take him
Brooks
away.
to abide by the simple
I've
rules.
Look at
never
this
of
guy's
decorum.
face over here in the red
and
shirt. He's
civility.
laughing.
Your Honor, I don't
He is-
consent or agree.
Take him
to what
away.
You are doing.
Your lack
don't
of
give
consent is
consent.
noted for the
I
record.
You don't
give
need consent,
to
sir.
an estoppel. I don't
I'll
give
make a more
consent.
full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
from
Reporter,
being
the
able
record
to
should
exercise
reflect
my
the court is
Too bad.
stepping
right.
off the bench. You may step off.
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
Oh my God. She walked out. She's done. The judge is like, I'm finished.
I mean, it's ridiculous.
This is insane. But this is going to be the entire trial. This is what happens when someone represents themselves.
Mm-hmm.
And they're not he's not an attorney, but even if you are an attorney, you shouldn't represent yourself. It's really dumb.
Yeah. But a lot of people were asking, why is the judge not stopping him sooner? Why is the judge letting this happen? What needs to be understood here is that when you do represent yourself, lawyers know law obviously better than the average citizen because that is their profession. So they're able to know what's like constitutional and what's not constitutional already. The fact that lay people don't, it almost puts the pressure on the judge to make sure that everything is constitutional
Oh,
in the
she
sense
has
of
to.
your rights. Yeah. So it puts the
She has
pressure
to
on the
be
judge.
she has to be incredibly patient, because if she isn't and he finds some lawyer to appeal on the basis of, they were unfair to him somehow in this process, it can be overturned. So
Right.
they don't want that. So you have to be
Mhm.
extremely careful with pro se litigants that you don't violate their constitutional rights. But I didn't see any of that here. I saw him violating court rules over and over and over again.
Mhm.
So her objections were fair. So they're still just like, I don't know what they're doing. So I'm just going to remove that out of here, and I'll let you know. I'll put it back up if they come back in. But Farron, welcome to the show. Thank you for being here.
Thanks for having me.
I've been wanting to talk to you for ages. I was watching your coverage of the Johnny Depp trial, and that was so much fun. Will we
Mhm.
ever have that much fun ever again? Because I sometimes feel like we won't.
And it's one of these things. And yes, Michael Palmer, a layperson like myself, like Megan Fox, we are in
That's
the
right.
media. We cover these cases a lot. And while we might not be lawyers, when we cover per se cases, Megan, I'm sure you've had. I'm sure you haven't had as much fun as this one. Mhm.
The pro se cases that I've seen, I've not witnessed in person. Most of the time, you don't get to see this in person. So this is actually kind of a fun event.
Mhm.
Most of the time, it's people I know who are going pro se in family court because they're left with no other choice, because the
Right.
lawyers that were supposedly that they paid to help them didn't help them, and they feel the lawyers are working with the system. In those cases, I still don't recommend it. I still
Yeah.
feel like you need to go outside of the county maybe and find a lawyer who doesn't work with these people on a regular basis. But pro se is tough, man, unless you're going in front of a judge for something really simple, like a Open Meetings Act violation, which you absolutely could represent yourself on. Like, because all you have to do is open the books and be like, okay, this public board violated the Open Meetings Act in this particular way to me when I was there. Judge, look at it and tell me what you think. And the judge will be like, well, did you violate this? And they would be like, well, yeah, we didn't do that. And then the judge would be like, okay, you lose.
Right.
So
Mhm.
that's like the only thing I can think of where going pro se, I know people who've done it, where it's kind of a safe thing. But
Yeah.
if your liberty is at stake or your children's custody is at stake, no. God,
Yeah.
no.
Because I was say, even I think the only other thing as far as a journalist, like the recordings, like a recording law, like a recording violation, you could represent yourself and say like, hi, DC is an all party consent state, or such and such is but I think even still journalists would want a lawyer just
Yeah,
to
no, you
cover
have to
their
have one.
asses.
Yeah, you
Yeah.
have to have one.
Yeah.
Are they bringing court back with him in the other room? I don't know. It looks like court TV or Law and Crime ended the stream. So I guess they don't think he's coming back, but that would be weird because hold on, that would be really strange. Because she didn't rule yet on his motion.
Yeah. They got nothing done.
They got absolutely nothing done. So let me go and see if they started a new stream, because they might have. So let's see what they did.
Oh, we got
Uh,
some sex spots.
Again?
Mhm.
Mods,
They're
you're
back.
falling down on the job. Please take care of the sex bots, mods.
There we go.
All right, let's see. They did not put up a new live stream, so no clue. No clue.
Mhm.
That's weird. Maybe they're just taking a break and they'll be back, but if they were, they would have left. I think they would have left the live stream going.
Yeah.
So, I don't know. I'll keep an eye on the YouTube page and we'll see if they come back.
Mhm.
But that's bizarre. All right, so you and I have a lot in common. We have both worked in media for a long time. You
Mhm.
worked in big media for longer than I did. I only worked there for a couple of years for ABC.
Mhm.
Um, what what made you strike out on your own?
Um, let's see. Now, the thing is that I worked local news, which sometimes I feel is way busier than the national stuff
Totally.
because I mean, you're on the ground, you're in the courtroom, I mean, that's why like there were so many times, and I don't know if you ever felt this way, but like you'd be covering this story like front to back, and then they'd be like, okay, give all your notes to like Dan Rather, or oh, give all your notes to not Dan Rather, he was an anchor. Trying to think of some of the reporters now, like Jim Acosta, like give all your notes to him because he's got to go live on this. And I'm like, why don't you just have me go live? And then he would go
Why not
live.
send you?
Exactly. And so a lot of the local news reporters that do really work hard and do great journalism as much as they can get gypped on stuff like that. But what kind of made me leave was when I got into TV, it was right after I graduated around 2009, 2010. And it was when the local news started changing. In journalism school, or as we call J school, we were told we were going to get a reporter or a photographer, a live truck operator. All you had to do was focus on the story. Your photographer was going to shoot everything and edit it for you. Your focus is just the story. And then I get to my first news station and they're like, yeah, so there's your camera. And I'm like, well, where's my photographer? And they're like, oh, you are your photographer. And it was, you do everything on your own. You shoot, you write, you edit, you put it all together. And that's where I tell people, young kids that are like, I want to be on TV and do journalism. And I'm like, you're better off starting YouTube if you don't want to have to do all of this outside work. You're out in the field, it's pouring rain, you're covering an accident. By the end of the day, you don't even want to be on TV. Now, I do see that Nick has something up now. So I
Does
don't know
he?
if you want
Oh,
to check.
yep,
Yeah.
they put it back on.
Yep.
Okay.
She just
They
needed a
put
little
it
bit of a breather.
they
But
put it
yeah.
back up. The
Yeah.
judge needed to go back and take another Xanax, I think. So now she's back and she's fully medicated. Let's see.
Or just take a hit.
Once
Wisconsin is a
Mr. Brooks
pro weed
removed
state.
from this courtroom to the
Perhaps
Or
she
at
had to
main
least
get a
medical.
gummy.
there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom. I have cited
Don't count on it,
repeatedly
Shawnette.
from Illinois versus Allen, which is the Supreme Court case from 1970, which provides this court with the authority to remove Mr.
Oh, she was
Brooks
looking up
from
the case.
the courtroom. Because it is a new day, I think it bears repeating much of the language that is directly on point in this decision. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not.
Keyword elementary.
I was just going to say that.
This is the Supreme Court stating, we believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle an can't say that word all the time.
Brian,
Obstructive.
he's still able to hear them. He's just in a
defendant
different room.
like Mr.
There's
Brooks.
no problem.
In that
He's
case,
still
we're talking
involved in his
about,
own trial.
the defendant, Mr. Allen. And here are
It's just they're able to
3
mute him.
options, at
Right.
least that the Supreme Court acknowledged. But I would note, as they just said in this prior quote, there are at least 3. 1, bind and gag, thereby keeping the defendant present. 2, cite the defendant for contempt. 3, take him out of the courtroom until he promises
Bind
to
and gag.
conduct
That was with the
himself
Chicago 7.
properly.
Remember
Bind
that?
and gag.
They bind you to the
Wow.
chair and gag you.
This court has
Wow.
That was with the
repeatedly
Chicago 7.
utilized the neighboring courtroom
You haven't seen
because
the movie.
I
Great
believe
movie.
I
provides
have not.
Mr.
I would
Brooks
love to
with
see
an
that, though.
opportunity to meaningfully participate
Amber Heard
in
should have
these
been bound and gagged
proceedings,
in that trial.
while this court
Mhm.
maintains decorum, dignity,
She could have held him
and
in contempt,
respect.
but she didn't.
Yeah.
It is an elementary standard of proper
Yeah.
conduct to not interrupt.
And real quick, the reason why bind and gag
Mr.
was added by the Supreme Court is because they did that with the Chicago 7
interrupts.
to the one black
I
guy.
gave him
And
9
they added you could bind and
warnings
gag.
Jeez.
I removed
Look at
him
him. He's
to the other
Oh my God, I want paper. I want this. Halloween 2022. Right there.
As the court did in Allen, this court decided that under the circumstances to remove Mr. Brooks from the courtroom and to continue the trial in his absence until and unless he promised to
Objection
conduct
hearsay.
himself in
Oh my God, I don't have a case.
that this is the proper response to his conduct. As noted in the Allen decision, the court stated, we find nothing unconstitutional about this procedure.
I need a screen grab of him
This
holding
is
up the
now
objection
the
sign.
third day of the trial.
Oh, it's so funny.
We struggled at times through jury selection with multiple interruptions, what I would describe as disruptions. So it's with that history we came into court today. Mr. Brooks persists in his unruly conduct.
He's very unruly.
I would note, just as the court in Allen did, it is not pleasant to hold or to find that Mr. Brooks be banished from this courtroom as part of his own trial to the neighboring courtroom. And this is what the Supreme Court went on to say, but our courts, palladiums of liberty as they are, cannot be treated disrespectfully with impunity, nor can the accused be permitted by his disruptive conduct indefinitely to avoid being tried on the charges brought against him. It would degrade our country and our judicial system to permit our courts to be bullied, insulted, and humiliated, and their orderly progress thwarted and obstructed by defendants brought before them charged with
God,
crimes.
is that funny?
As guardians of the public welfare, our state and federal judicial systems strive to administer equal justice to the rich and the poor, the good and the bad, the native and foreign born of every race, nationality, and religion. Went on to state, but if our courts are to remain what the founders intended, the citadels of justice, their proceedings cannot and must not be infected with the sort of scurrilous, abusive language and conduct demonstrated by not only Allen in that case, but by Mr. Brooks in this case. I've also cited repeatedly to SCR Chapter 62, which contains the standards of courtesy and decorum for the courts of Wisconsin. I've advised Mr. Brooks repeatedly. I've had, just as I am holding a copy of Chapter 62 on yellow paper laminated, I have it myself. I provided it to the state. I provided it to Mr. Brooks.
Oh, my Lord.
And those standards govern what I do, what the attorneys do, what lawyers, clerks, court personnel, even witnesses, defendants, jurors, and others appearing in the court. Two of those subdivisions specifically talk about the expectation that within the courthouse, that those involved in the proceedings refrain from creating disorder and disruption. Another subdivision of that section discusses the expectation that those within the courts conduct themselves in a manner which demonstrates sensitivity to the
Yeah,
necessity
she's
of
being so
preserving
careful to
decorum and
cover
the
all the bases,
integrity
but it's like,
of the
honey, you
judicial
don't need to. We all
process.
saw this.
Once again,
Right.
it
But
did
you know
not
what,
You're doing
though?
the right
Mr.
thing.
Brooks very long to
The
begin
part that
interrupting.
sucks, though, is that
It is 2:39
in an
now
appeals
as
process,
I go
a lot
through
of times they
this
don't look at the video, they look at the
decision
record.
making
Yeah.
and put my findings on the record. But his behavior started very early on. I gave him ample opportunity to abide by the rules of decorum. I gave him ample warning before he was removed. This court, frankly, has no other option at this
He just
point
objects to being on trial in general.
other than
Mhm.
to
I
put
object.
him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings. With that, I will turn back to Attorney Opper. I am going to unmute
I'm
For
adding
someone-
this
for
into the
Brooks,
bank
but
of
also advise him
photos that I
that
use.
if he interrupts Attorney Opper
For someone
or
with
others,
COVID,
as
his
they are
arms are not fatigued
providing
anymore.
testimony here today,
His
I
arms are
understand,
suddenly very
he can
energetic.
object.
hmm
However, my expectation for that objection process would be that he say, I object. He provide a basis. I oftentimes give parties, give me one word. Is it hearsay? Is it,
Yes, he
calls for
killed kids.
speculation? Is
Yes.
it irrelevant? Whatever it may be, a very either 1-2 word objection or a very short summary statement of the basis for his objection. After he does that, I will rule on the objection, and I expect
This
him
poor
to
judge is
honor
teaching
the
a Law
ruling
101
that I have
class.
made.
Yeah.
If he can't do any of that, he will remain
Again, she just has to be
muted, and the
so
process
careful.
will then
careful.
be we've given him a
'Cause this
sign. He's
dipshit
holding it
could
up right
appeal
now,
on-
demonstrating for us. He has the objection sign. He will be required to write down his objections on a piece of paper that will be provided to the bailiff. The bailiff will provide it to me, and then I can
No,
rule
Rod,
on
I
those.
didn't see that
Even if
yesterday,
it's
but
striking
I would think there
testimony
would be
later
arguments
on.
to
I do
declare him
expect his
incompetent
objections to be
and
based
assign
in
him a
law.
lawyer. I would imagine that's
He,
true.
I know, was provided.
I think
with
she's letting
a
him
copy
hang himself
of
right now.
the selected
And then
statutes, including the rules of evidence.
If he can't follow the basic rules,
All right, go ahead, Attorney.
which is
Opper,
why I
for the
think she
record,
said even
the
the
mute has
elementary
been
rules
undone.
he can't
Mhm.
follow to
Thank you. So,
lead
Ms.
up to
Wolonup,
the
I was asking you
incompetence.
about the digital discovery materials. You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold on
about
a second. Mr. Brooks, the basis for your objection at this time?
If you're just joining, Mr. Brooks said that he had no access to any of these files because he had COVID and was COVID protocol to be isolated, which was a lie.
it was a lie.
Your objection is noted. It's overruled.
We can no longer
Her
hear him
answers may
anymore, which
stand.
is kind
Next,
of good for
you
us,
may
I think.
Continue, Attorney
Yeah.
Opper, with your next
His
question.
microphone is very muffled.
the
But don't worry, he never says anything that makes any sense.
nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer. Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer. Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day.
Objection.
Overruled. Correct, ma'am.
Sorry.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Objection to what?
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
That is correct, ma'am. Correctional officers would transport it, but yes, there's a card available.
Sure. Mr. Brooks had told this court earlier that he started feeling not
He objects
well,
to
I think were
everything,
his
Shawnette.
words, over the weekend.
Just everything.
And is there any notice to any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess that maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection? Just a comment under your breath. It's overruled.
You gotta think about it.
if he were to complain of illness to a
The guy in the back. The guy in the back.
that in any way,
He's
They would give him
The guy
a
is like this.
form to fill
fucking
out, which would
shit.
go to the medical
Prosecutor's
department,
table
or he
is
could-
having a hard time keeping in the
medical staff, or it could be
guffawing.
documented in the jail
Oh,
handbook.
The
Your
slow
knowledge, was that
raising
done
of the
by Mr.
objection.
Brooks last weekend, the weekend of September 30th and October 1st.
Not to my knowledge.
Oh, God.
And are
Now
you
I am
aware of
strictly
fact
watching
that
the guy.
last weekend,
Now we have to watch
on or
him.
about
Yes.
Yeah.
Saturday, he requested a shower and a shave.
Yes,
Was that provided to him?
yes.
Yeah, Daryl, they know your whereabouts 24/7, bucko.
On a protocol, would he still-
They know when you shower. They know when you eat.
Depends.
It would depend what type of a protocol.
They have your phone calls.
Yep. That's called jail, buddy.
Those were all my questions. Thank you, Ms. Wollenhop.
Oh, the porn
Mr. Brooks,
spammer
do you
is
have any
back.
follow-up questions for Ms. Wollenhop?
I do. That it would depend on what type of protocol I was on, would dictate if I'm able to shower, correct?
That was not completely what I stated.
Well, that's what you just stated on the record.
Well, different management protocols, it would be in accordance with jail operations, and my preference, Judge, would not to be to speak to all of the jail operations.
Right, I'm not going to require her to speak to all the jail operations. If you wanted to ask her, for example, whether your current protocol would prohibit that, I think that would be a fair question.
So that would be the question then. Well, no, let me ask this. What specific protocols would prohibit being able to shower?
Objection, irrelevant.
I'm not going to, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols, given the operations of the jail, but you may ask her if there's something specific as to you.
Well, because of my situation being a little bit unique, would any protocol that I am on currently prohibit me from being able to shower and or shave?
He's talking about showering and
Do
shaving
you speak
now?
moving forward?
What?
As of right now.
Why would his protocol
You
keep
would
him
be allowed to shower on the
from
protocol you're
showering
currently
and
on.
shaving?
Would I be able to shave?
This is so
You would
stupid.
be able to shave.
Would that be with the clippers or a razor?
Clippers or razor?
She may answer.
Mr. Brooks, we would monitor behavior and other factors in that and make a determination. There's
He's now asking if he can
procedures
shave with
operationally in the
clippers
jail that
or
you
a
can
razor.
request
This
those
is.
Oh, yeah.
I object. I object.
and
I have an
you'll be
objection, Your Honor.
The COVID protocols.
Correct, ma'am.
So, to your knowledge, are you aware that we are only permitted, and I'm saying myself as well, being
Daisy.
housed in the jail, we are only
Please.
permitted razors once a week and clippers only once a month?
Judge, I would prefer not to answer questions in regards to jail operations.
Right. I'll honor the request of the jail administrator. It goes beyond the scope of this hearing. She need not answer general questions about the general procedures and protocols within the Waukesha County Jail. We're a little far field. I gave you a little bit of leeway, but we had started this off about COVID protocols and your current situation.
And
so
now we're talking about shaving, and
I
this is just not
from
why
my
we're here.
perspective, the
Mhm.
questions regarding the discovery materials and all of that were relevant because you claimed you weren't being allowed out to a conference room. That to me implicated your ability to prepare for your defense and this trial. So that's why I allowed those questions. Whether you shower or shave would, in my humble opinion, not be relevant to the
It's
issue
not
of
relevant.
whether you
No.
can assist in your own defense.
Well, respectfully, Your Honor, that was brought up by a prosecutor. It was brought up about the whole issue of being able, me requesting to be able to shower and shave, so that's why I.
Oh, for God's sake.
I understand, and I'm
Subscriber
under my
mode activated
authority under
to get rid of the
906.11,
porn bots.
I'm going to advise both parties that anything regarding those types of things are not relevant, and I won't allow questions from either side regarding that any
Yes,
further,
this is
at
all
least
about delaying
today
a
on
process.
this particular issue.
Thank you, Your Honor. I would want to make one correction for the record. I never claimed not to be able to have access to certain things. I merely claimed that I'm on a protocol which limits me even more than I'm already finished. I made no reference to anything in specific, just the fact that I'm on a protocol which restricts me to my cell until the test can come back.
I appreciate that clarification, sir. Thank you. Do you have any other questions for Ms. Wollenhup?
Yeah, a couple more.
I would love that, Dobre, if they had giant oversized buttons to hit and neon signs would light up that say objection.
Mhm.
That would be fantastic. We need that.
The types of protocols that I am currently on outside of the COVID protocol.
Objection, irrelevance, goes to jail operations.
Sustained. Next question.
Does my specific protocol change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm going to have her not answer that as it goes to.
Well, that directly goes to that because as we know, I'm only on a protocol where I'm only allowed out of my cell a few hours a day as it is. Now being restricted to my cell because of the COVID protocol.
No one cares.
The question I'm asking
No
is,
one cares that you're restricted to your cell.
restrict even
That's not what this hearing is
the time
about.
that I can be able to be out to utilize the things.
Wouldn't he have to take this up with the jail administration? Like, why is he wasting the court's time with this?
I'm already limited.
Can I add?
Farron, you're
I wanna
team
make sure
balls,
I
right?
follow you.
The
Oh,
chat
100%.
room-
I'm sorry
no,
for the
100%.
interruption.
Of course. I could have
If I'm
answered
hearing
that.
what you're saying correctly.
My sister was no balls.
What?
You may have a belief
Yeah.
that
I don't
your
understand
access to
team
certain
no balls.
things that would
And Nick was
impact your
like, that means you're gay. And my
ability to
sister's
prepare
like,
for this
whatever.
case is impacted by the COVID protocols. Is that a fair assessment of what you're trying to convey?
I would say that would be accurate in a sense.
And so if we ask the jail administrator that specifically, is there anything about the COVID protocol that would interfere with your ability to have access to materials or a room?
Yes, Listrid. Yes.
Does that,
And if you're not
is that a question
subscribed,
you would
what the
want
heck is your
answered?
excuse?
Yeah.
Hit the button.
All right, do you understand what he's trying
So
to
what
ask?
I'm understanding is.
Farron, your sister is weird.
Mr. Brooks has legal material in his cell. He
She's
will
very
remain in
beautiful,
his
but
current
very weird.
housing location.
No, she didn't get the question
Access
because
to
she
the
was like, I
conference
don't
room,
get it. She's like, I
will
guess
not change
no
that,
balls.
which is outside of his
But she like
housing
doesn't
unit.
care about that stuff. And Nick's like, that
And
means you're gay.
access
And
to
she's
the
like,
phone could be granted
okay.
upon request in the day
She just
period.
doesn't let anything bother her.
Right.
So I do not believe the protocol limits his access to legal material.
Thank you. Do you have any other questions?
Yes, I do.
Oh, of course he does.
Telephone. To the best of your knowledge, are you aware that there is a certain times that the phone will be available? You have other inmates that
Let's not talk about other inmates, but
He's talking about the
again, I'm
phone
sorry
being
for the
available?
interruption, but I want to try to get us through these questions. If you're asking,
Okay, let me ask it another way.
okay, go ahead.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have.
Is he aware that Joe Biden said that the pandemic's over?
Would I be able to utilize?
Do they get the news in prison?
Someone should tell him you don't have COVID, even if you have COVID, because the pandemic is over.
Yeah.
Or would it be strictly by me having?
My kids had a cold and they went to school with their colds and no one sent them home and no one asked me to
I
test
guess
them
I'm
either. So
unclear
it's
as
definitely
to the
over.
It's
manner
over.
you speak of. What are you referring to?
I think I was very clear with.
Are you trying to
You
ask
are
her?
aware, are you aware, which I know you are, that the protocol that I'm on outside of the COVID protocol prohibits me from being able to utilize the phone at certain times of the day? Would the COVID protocol prohibit that any further?
Mr. Brooks, are you trying to ask whether the COVID protocol impacts your phone privileges?
That's what I
Yes.
just said. No, not in a sense, because
Oh my
I
God.
think it's more accurate with the way
He's
that I
doing
have
this on
it.
purpose,
But your
Farron.
question
Mhm.
assumes it's not an evidence and that are beyond the scope of this proceeding.
This is
I'm
purposeful.
concerned about what
And he thinks he's smarter.
any
I
impact
know.
the COVID protocol
Although,
has on
to
your
get to
ability
be fair,
prepare for this
if
case.
he's just trying to delay the shit out of
So to
this,
limit
he's
your
doing a very good
questioning
job.
Right. Mm-hmm.
in that way.
No, I know you can't hear him, you guys. That's because they put him in a different room and the microphone in there is not as good. So, but you're not missing anything.
Reason why we're
Yeah.
having this didn't have anything to do with limiting my preparation.
So
That
you're
wasn't the real issue.
He doesn't
think
know
it's
how to
related
ask
to
a
the-
question.
I just wanted that clear.
I understand.
That's all.
I understand what you're saying.
Holy shit.
I respectfully disagree. That's why I've allowed some of the questioning. I believe it's relevant to the motion that's before me for this court to know how the COVID protocol specifically impacts you and your ability to prepare for this case. I understand you might not be claiming the latter to be an issue.
I need a drink.
Mhm.
Like
but
I'm ready to
nonetheless, I
start
think it's
pounding
appropriate for
shots
the court to consider those
to
things.
get through this.
I heard
This poor
the jail
judge.
administrator indicate
All we needed was an
that
excuse, and
the
you gave
phone
us one,
privileges
Daryl.
would still be available
You
upon
gave it,
request, and I
Daryl.
guess to
On
the
a
extent
silver
that's
platter,
different,
baby.
if at all, from the
I'm going to
standard
open an
protocols that
entire
you're
bottle of
under, I
wine
would
and
accept
just
that
sit
as an
here and
offer
pound it.
Okay.
This is,
Well, I didn't agree.
what time is it?
The reason why I brought it
It's
up
almost 4.
was because
It's-
I've been on the COVID, outside of the COVID protocol.
I have nowhere to go.
The protocol that I've been on.
Drunken debauchery upcoming. Bring on the baby oil.
So
You're funny.
Woo!
You know, nobody really wants to see that. They like to think about it, but
All
no
right,
one
Mr.
really
Brooks, we're
wants to
getting
see
a little
that,
far
Farron.
field. I need to make
Just
a
the thought.
determination on your request. So I'll ask you one last.
It's one of those things that kept in a fantasy is a
I
much
won't.
better idea
Mr.
than the
Brooks, I will
reality,
ask you one last time. Do you have any other questions for
which
the
would be
jail
me slipping
administrator?
and
'Cause
breaking
right
an
now you're
arm
talking more about
within the
things
first
you would provide.
10 seconds.
So if you have a question that's
Yeah,
relevant.
both of us going down, not from each other.
Not
just
from each other.
From the bottom of
Just
the pool.
whoops.
what did I say then?
When you provide
Legs
information
flying.
through just
Ladies and
a
gentlemen, there will be no
statement
press
about
conference
things
today.
that's not
Crying in
evidence,
ice
right?
packs.
The
That's
witness on the stand is providing us testimony.
That's what
Testimony
I
is
see coming.
evidence. Not that I wouldn't accept certain statements from you, but also understanding the state has the ability to challenge those.
If I were this
by
judge, I'd be
asking
drinking
questions
right
of
now.
the jail administrator or other
Yeah.
individuals so that I can make a determination today on your motion. With that, Mr. Brooks, do you have any other questions for the jail administrator?
Phil, at some point here, a trial will start.
Not understanding that I have, Your Honor.
Mr. Brooks, one last time, do you have any additional questions for the jail administrator?
Your Honor, what you're doing right now,
What kind of
Mr.
porn are
Brooks
you
has not
watching where
answered-
there's
he's
ice
gonna- Mr.
packs and
Brooks, I need to make a
crying?
ruling right
Kamala,
now,
that's
please
what I
stop.
want to know.
He's not answered
What?
my repeated question
Injuries,
as to
ice
whether
packs,
he
and
has any
tears.
additional questions for the jail administrator. Unless there's any further questioning from the state based upon the additional questions that were asked, then I'm going to have her step down.
I just want to ask of the court.
Man, I
if
want to
you're
get my
intending
hands
to
in her
take up
hair.
His inmate communication form that was dated September 28, 2022 as well. While Ms. Wollenhop is on the stand, I just have a few questions related to that, Your Honor.
I object to that. Relevancy. What does it have to do with she's testifying to right now today? They're two separate issues.
I'm sorry, I don't know the document. Oh, I do have the document number, 258.
Objection for relevancy.
Hold on, Mr. Brooks.
Oh, he used a
I need
word.
to find the document in my record. 258, you said?
Yes.
Ooh, I like that idea, Dobre. I should head up the investigation of family court corruption. Yes, I would like that.
I'm just going to print that off for ease of
The very first thing I would do is put cameras in every
my
single damn
reference. I am
courtroom
going to allow
Yeah.
and live stream it.
the jail administrator to be questioned regarding document 258. I don't know if Mr. Brooks has a copy of that in front of him or not, so I will print it off in that courtroom.
Well, she can
that
print
he has
directly to
that.
his room.
So that I have this
That's funny.
correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today. How do these are two separate issues?
The
She
court
doesn't even know.
recognizes that they're two separate issues, but I also have the authority when considering judicial administration and economies of scale, shall we say. We have the jail administrator here. It's an important housekeeping issue as we go forward. And so I'm going to address it.
I feel like we've
after
been
I
here for
address,
days and it's only been a
the,
half an hour.
Yes.
motion to adjourn that you filed, but since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Is the judge leaving again?
I think
had
she
to
just
talk to
walked
my
out.
kid. Oh my God.
Statements noted of record. All right, go ahead, Attorney Opper.
Ms. Wollenhop, I don't believe you have the document in front of you, but
Record to reflect and handing her a copy of what is in the record as document 258.
thank you, Judge. I'm sorry.
It's okay, I'll print out another copy for myself.
Okay.
The judge just threw up her
Someone
paper,
confirm
threw the
whether that
papers
document
over her
was
head
given
and
to Mr.
walked out of the
Brooks as
room.
well. I did print it to the printer over there. I have that ability. It was. All right, thank you. The record to reflect, he has also been provided with a copy of document
Eric,
number
no.
258.
The answer to that is no.
I'm not acknowledging that document, Your
Family
Honor.
court video
I'm
should
not
not be
acknowledging
sealed
that.
for any reason, especially
All right, I'm
privacy,
gonna need
because
them
that's
to
what
be
keeps them
interrupting
that's what keeps
Mr.
them
Brooks.
doing
It's
the
a
bad things they
document you
do.
filed.
They could
So,
redact the children's names. They could put a kid
and
behind a
it's
screen if
document
they
that
had
was
to talk.
filed through the inmate communication form process. It was scanned in on October 3rd, but it's dated 9/29, and it's directed to either clerk of court / Judge Doro.
Look at him. He's just, this is,
Ms. Wollenhop, you've seen a copy of this document previous to today, correct?
Yes, ma'am.
And you're aware that it's dated September 28, 2022, correct?
Correct.
And purports to have been written by Mr. Brooks himself, correct?
Correct.
And in this communication to the court, Mr. Brooks indicates that he is on a quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form, near the bottom, the last two sentences He indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Correct, that's what he states.
Okay. Is that a truthful statement? Well,
It
let
is.
me ask him different. That's a bad question. I strike that question. Did Mr. Brooks have access to his legal materials during the time that he was under a?
Oh, so this is addressing his complaint.
Yes, ma'am.
Again, that would be the banker boxes of written discovery in his own jail cell.
Correct. Anything that was in his jail cell, he would have access to. and
Okay.
He would also have access to the conference room and a tablet.
And the
in his
tablet.
cell.
Okay. And that's the legal materials that are provided to him are on that tablet and on the computer in the conference room.
Correct.
And nothing about that keep separate order affected his ability to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail
Oh, God.
administrator?
Yes, I do. You just stated on record that I had access to all materials for trial prep during the time of the keep separate, correct?
It doesn't specifically say what you don't have access to. So yes, what was in your cell.
You just say in open court on the record that I in fact had access at the time of this keep separate.
2 items in your cell, and you could have access to the conference room to view electronic legal materials.
So, am I correct in saying that when you brought over these discovery materials to the pod, that I was in fact in one of those conference rooms and I talked to you face to face? Is that correct?
You were in a conference room and we spoke.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
I specifically told you that I was on a keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about.
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you.
I know you guys
that I
can't
was on
hear
the keep
him. I
separate,
know. It's just a bunch of
that
bullshit.
was gonna hinder me being able to prepare. Is that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So, is there a way to verify when the keep separate went into effect?
Objection relevance. Well, hold on. Mr. Brooks, as I read this inmate communication form, and perhaps it's just a simple question, when you wrote it,
Every time the judge comes in.
did you have access to the banker's box of materials?
Yeah, if he took his mask off, we'd be able to
No,
hear
I
him
did
better.
not.
He's in a room by himself.
Mm-hmm.
Ms. Wallahop just testified the last time that she gave testimony that she brought the discovery materials over on Thursday the 29th. She did say that in open court on
I
the
agree.
record.
Yep, she said that previously.
He's a lawyer now.
This inmate request was written on September the 28th. At that time, I was already on the separate protocol, which does not allow me to come out of my cell.
But is the issue that keep separate protocol, or that you didn't have access to the materials that we've now established through testimony?
What is
you
keep
had
separate
access to
protocol? Oh,
once
the
they were,
COVID protocol.
delivered
Right.
to you?
Mm-hmm.
Yes, thank you. No, this is like half a bottle of wine. This is a giant pour.
Did you have your kid go get it?
Yes. Why else have kids if you don't train them to get you liquor?
Mother of the year.
Mother of the year.
No objection. No objection, Your Honor.
I can't do this sober anymore. This is just not possible.
take me and take me to another part of the jail, sometimes in the pod, in the secure shower is what they call it, which is downstairs. in
Sir,
another
I'm just
room.
gonna stop you because I honestly, the whether you have a shower or not is not relevant to the issue of whether you had access to the materials you need to prepare
Oh,
for your
God.
case. So I read this inmate communication form, especially that very last sentence. I am respectfully asking and requesting that my trial be slightly delayed as I have no access to the materials needed to prepare for trial. Thank you. So my question to you is, and I think you've already answered it, but I want to make sure, at the time you wrote this inmate communication form, the materials had not yet been delivered to you. Is that your testimony?
The boxes. that
Oh,
were
here he
brought
goes
over
again.
had not yet been
He
delivered.
cannot say yes or
I had
no. He
already
just
had,
can't.
Yeah.
Maybe 10% of the discovery materials that was provided to me by my former attorneys on this matter.
Right. So
That in itself was very, very voluminous in itself.
Sir, we had a prior hearing related to the access provided to you and when the materials were provided. You may recall that Attorney Perry even testified over Zoom audio about that. The jail administrator testified as well. To me, that record is very clear that the materials that were provided by your defense attorneys following their discharge on your case were received by you on September 29th of 2022. That has been established. No one is disputing that.
Which should have taken 10 minutes.
So
Almost
that's
45
the record
minutes
that
now.
I have before me.
Andrew Bronca might be stopping by
I
if he can
understand
get a
what you're
good
saying
signal.
about
He's
the keep
traveling by
separate, but
motorcycle
also at
somewhere.
that
Oh,
hearing, it was
He's outside of
made
Nashville,
very clear to
oh,
everyone
fun.
that
and he may
the
be
jail
dropping by if
administrator
he can get a
gave some specific directives as it
signal.
relates to you
Yes,
and
this is my
access
mega
to certain
pint.
things.
Absolutely. This is what we need for this trial. Liquor, because this
I
is
do recall that, Your Honor.
insane. This poor judge. I'm
And one of
drinking
the
for the
questions,
judge.
if you
Your Honor,
recall,
this is
one
for
of the
you.
questions I had about what you just said was, did all the officers know
Come
about
on,
that
man.
specific order?
Come on, Jack.
As it would be called. I don't know what it was exactly, but the information that was to be passed down from Ms. Waterhouse to the officers.
Right, and I'm not going to revisit that because you were given ample opportunity when we first addressed that to ask questions and to provide other information, meaning statements from yourself. And the clear record from that is that the information was put into the jail management system. It was documented, and that the jail administrator had no information to suggest her employees did not have that information and honor that information. There was no testimony from anyone else to suggest that that wasn't followed. So,
I would like to say something for the record, Your Honor.
Thanks,
Go ahead.
Eric. Appreciate the super chat.
To speak
Going
to
back
what
to
you
work.
just
We'll
said on
miss
that,
you.
it's possible that all officers were not aware of that. I even talked about this with an officer who worked just last night.
That's why I just responded. I was like 100%, 1,000%.
That he had been off for a few days, so to his knowledge,
Totally,
he wasn't aware
honestly,
of that.
the other
issue
night
came
when
up
he read
because I
Unbreaded,
specifically
I had to
asked
listen to it twice.
to
It was so
utilize
good.
his faculty.
It was
Now that
so
So
deep. I had to listen to it twice.
did you see last night's?
I'm not
No, I didn't. But
Have you
this is
seen it?
like,
Have you seen it with an echo where he does the
no,
echo now?
no, I haven't seen it with the echo. I missed the
I'm
I
just
missed
disputing
the
fact
the
that
auto tune.
every
He's got to
officer
get
that
that
works in my
fixed.
pod is
He
aware.
fixed it last night. There was an echo. It sounded
An
like he
echo.
was in a cathedral
all right,
Oh,
thank
that's
you.
saying it to his
fantastic.
disciples. I
questions
was on the floor.
at this point
Seriously though, a couple
for
like
the
last
jail
week, it
administrator?
was so deep. I had to listen to it like
Again, not related to the
2 times. It
shower,
was so good.
but related to access
Like,
to
You're like, am
materials.
I a
guy's
Matthew Ferris
crazy.
stand?
The guy's crazy, but he's also like he knows what's up. Obviously,
Oh, he does.
it was all about commercialism and how, they turn us against one another and they keep us distracted by things. It was so good. It was so good. It was like right on.
Really broad.
Last night it was all about how they try to put people on hallucinogens and
question,
how it's a
or
fake
rephrase.
alternate reality. And I mean, the messages are deep.
I know, right?
We should have a stream where we just discuss the pages and it's like beyond the bread.
Beyond the bread. I like it. Phil says, me too, Megan. I'm pounding youngling beers to this bullshit. Nothing like watching a mass murder of children and grandmothers make a farce of the justice system. Yeah, thank you for saying that, Phil, because that's how I'm feeling.
It's a
And you put it
compound
into
question,
words.
so you have to break it down one at a time. So rephrase.
Would it keep separate protocol restricting to cell confinement until arrangements can be made?
Oh God.
Judge, I would prefer not to answer that. It's due to jail operations. We would look at each
This
individual
poor
in each
woman.
situation.
Give
I think
her
it's
a
overly
raise.
broad.
Mr. Brooks, I'm going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this protocol limits you, specifically as it relates to access to materials needed to prepare for trial. Not generally whether you're on any kind of restriction, whether, but how, the
Oh,
focus
Shaunette's
is
back. How's your
how
roast
this
going, Shaunette?
impacts your ability,
roast
if at
doing all
all,
right?
Hopefully
access
better than
to
this
materials
trial.
needed to prepare for trial. Other than we've established that you didn't have the materials from your attorneys that were provided after they were discharged by the court until September 29th. I mean, we've established there was a gap, right? I granted the motion and allowed you to represent yourself on the
She's like, biggest mistake of
28th,
my
that was
life.
a Wednesday, and then the materials,
Yeah.
even though they
And
were
I'm seriously
turned
questioning my
over
life
to the
choices
jail,
at this point.
it sounded like in the evening on the 28th, there was
And I'm
protocols in
drinking
place
every
to go
time
through
I
that,
leave the bench and
then
go
those
into
were
my
provided to you on the
chambers.
29th. That is well
Because you are
established on the
exhausting me,
record.
sir.
So I understand that.
I've never
I'm
had a
going to
drinking
need
problem
therapy.
until
Addressed that in part
you.
previously, so I know the state
And I'm
wants
doubling
me
up
to
on pain
address
pills
this.
too.
Yeah.
I think I know the reason why.
So,
But if there's any question you want to ask the
Mr.
jail
Brooks, you've broken me.
administrator about what was going on.
I award you no
on the
points,
28th,
and may God have mercy
29th,
on your
even
soul.
going forward, that would impact your ability to have access to
I'm
these
appointing
materials.
myself a
That's the
court-appointed
type of
therapist,
questions you need to ask. Okay.
and I'm going to go have a session with him.
I asked the question.
She's like, I have thereby brought this rope that I will throw over this fan and tighten and
The discovery keep separate protocol at that time.
Oh, Victor says, I feel bad for the court reporter. Can you imagine her having to
This is
type
great.
his words? All these ridiculous words. Too many words.
How many times has she typed objection?
The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record-
I love this.
How
Brian,
to
yes.
turn a dry Mormon judge,
Judge
into an
into an
alcoholic
Catholic.
Catholic. The Daryl Brooks story.
Oh,
Next question.
I'd buy that
please.
book. 5 stars on Amazon.
I'd watch that documentary.
Hell, I would audible that book. I would read it for him.
Right.
Like I'll read it for free to put on
Brooks, do you
Audible
have
for
another
you.
question for the jail administrator?
Oh my God.
Please don't.
Please. Andrew Bronca asked me how long
The
this is
record
going to go
speaks for
on.
itself,
And I
sir.
told him, honest to God, I don't know. We could be here till tomorrow. I think this is going to go until the court shuts down tonight.
Were you aware, Ms. Wallahoff, that at that time,
Yes, Erica, she is going to have to hold his hand. That's what happens when you represent yourself. The judge has to now play your lawyer, basically, and explain things to you. And frankly, I don't think it's fair. I don't think it should be allowed. I got to tell you. I mean, maybe it should be, but
What date are you
I've never seen
referring
it
to,
go
sir?
well. I'll tell you that much.
the date
Didn't
that you
Ted
brought
Bundy
over
represent himself?
Yep.
the discovery
And he did
material,
terribly
But he went to
too.
law school at least, so
He
he
did-
had
he-
some.
that date,
Yeah.
And
But I
will
think
come
I
with a
don't think he
separate
ever
protocol.
graduated or took the bar.
You previously
I
asked
gotta
me if
fact check
I
that.
recall the
Hang on.
discussion you were informing me.
But that's
I
not the
also
question
find it
now.
kind of offensive, though, that
I was
someone who
aware.
murdered a bunch of people is allowed to address the victims, you know?
Right.
That
Like,
you brought
ugh.
over the discovery
The other thing
material,
with Ted Bundy too,
were you aware
legal
that
vices at University of Utah Law School. He sat in Ted Bundy's seat
I
the
can't
first
state
day,
for certain
and the
at
teacher was
that
like,
moment in
his
time.
professor was like, "Oh yeah,
aware
Ted
you
Bundy
asked
sat there,"
separate.
because the guy taught Ted
Can't
Bundy.
Oh
state
my
one
God.
Jeff was
day
like,
that I was not
"Okay."
aware of that. I think it was due
Oh
to a
God,
complaint
Can I have a
that you
different
sent
chair?
forward to the jail.
I'm gonna get up now.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he
Yes,
has
Mr.
had
Brooks, we're
access to.
far afield from the
Far afield.
issue at hand, so I'm going to
You can
ask
say
you
that
one
again.
last time. Do you have any additional questions for the jail administrator?
What are you allowed and not allowed to do on the keep separate protocol?
Objection, relevance.
Sustained. All right, then, I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
Mr. Brooks, I'll give you one more opportunity then. They need to be relevant. They need to be within the bounds that I've already discussed.
Kamala, yes.
That
This is the
was
type of
no,
questions
no,
this
the-
guy is
that's
asking. Like,
The
it-
issue is limited to the
It's-
impact of the keep separate.
Can I
on
shave
your
with
ability to
a
have
razor
access to materials needed to
or
prepare
an
for trial.
electric
But
razor?
Your Honor, with all respect,
What?
every question that I asked that had relevancy to that was either overruled or she was directed not to answer that.
Mr. Brooks?
So how the
Mr.
questions
Brooks,
that
you
I'm
indicated
asking-
you had other questions. I will give
Yes,
you this
please.
opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another
Would I be-
question?
would I be allowed out of my cell on a keep separate protocol?
Vague, Your Honor. The question is, was
Far
he allowed
afield
out of
here.
his cell to
Far
access
afield.
his legal materials?
Far
That's not what
afield.
I asked.
Right.
Judge.
The
Ted
question you
Bundy
asked, the
attended law
objection is
school
sustained.
the
If
first
you'd
year
like
twice
to
at
ask
two
the
different law
question
schools,
suggested by
but
Attorney
never
Opera,
finished.
that would be
Didn't finish. Okay.
permissible by the court.
No, I would want to ask my own question. Thank you. Was I able to come out of my cell on the keep separate protocol?
Judge, I would prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not answer that question.
So his argument is that he was not allowed to come out of his cell to access
beyond
the
the
discovery stuff. Is that why?
Yeah,
doesn't he
he's
just
he's
answer
saying
the
because of the
question?
he's saying because of the COVID protocols, he hasn't been able to
Mr.
access
Brooks, do you have any other
anything.
questions?
Well, she should just answer that question then. Was I allowed to come out of my
I do not
cell?
understand what beyond
Answer the
scope means.
question.
That was a direct
One last time,
question.
sir.
She
Do
doesn't
you
want to
have
answer
any
that
other
question.
Here we
That
go.
was a direct question.
All right, I'm going to mute him because he's now not being responsive to the question that I asked, and that is, does he
This is
have
all
any
his fault, by the
questions to
way.
ask the
If
jail
he had a lawyer,
administrator,
he wouldn't
within
need
the
access
scope
to
that
the
I've
discovery because the
previously
lawyer would
outlined.
have it.
Any follow-up from the state?
No.
All right, thank you. You may step down.
PD says victim's family members will be appointed to shave him daily with a straight razor until we no longer
Yeah.
need a trial.
Oh, I'm
You
sorry.
know-
I was thinking at Eastern time. We've been at this
Right,
for
does the
2
state have
hours.
2 hours.
Any other
2 hours
witness
already.
or evidence you
We're
want me
still
to
talking
consider
about
related
showers
to either of
and
these
razors.
issues, the motion to adjourn or the inmate communication form dated September 28 of 2022.
Nothing else from the state, Your Honor.
Mr. Brooks, do you have anything else related to the inmate communication form
God.
dated September 28 of 2022?
But she has to ask him.
I know.
Obviously included that after we took up the other issue.
Yeah, I'm still, I don't understand how, any questions that I was asking, are not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony, or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022?
yeah, I would like to, is it a way that we can verify the standards of the keep separate protocol?
Mr. Brooks?
To be able to show. the
Mr.
court.
Brooks, please listen very carefully.
Oh, God.
There's a question I'm asking you is, do you have any other
I don't
evidence,
consent to being asked a question
document? All right,
when
then
you
I'll,
can't even answer the
all right,
question.
I'm going
Then-
to.
okay,
mute
we're good
him
here.
once again. He is not answering very clear questions.
She's just setting it up that he can't represent himself properly.
I asked him if he had any information, evidence,
needs a
testimony,
lawyer.
documents he
That's
wanted
what's
to
best for
present.
him.
Instead,
Literally,
he
that's the
asked
best
me
thing
if
for
I
him,
could
is
verify
Well, first of all,
lawyer.
this guy doesn't deserve any best of anything, but
This is true.
Role. This is an adversarial system of justice here in the United States and in Wisconsin. I preside over that, but it's up to the parties to present information, evidence, testimony to the court so that the court can address the request.
She does
and
have
make
glorious hair.
decisions.
Mhm.
I would
So
refer
shiny
Mr. Brooks
and
back
voluminous.
to
Daisy, my ex needed a mute
the
button.
I know if we could all just have that in life.
waiver of attorney form
Wouldn't it be
that was
great?
discussed last week.
Okay. You don't have to tell me first.
Yep. Hold it towards the camera because that's going to make her stop.
It is document number 244, scanned on the
I feel sorry for the
28th
lawyer
day
who's
of
going to have to
September
step into this mess.
2022, wherein Mr. Brooks was advised that the judge cannot be his attorney, cannot give him any legal advice. The district attorney cannot be his attorney, cannot give legal advice. The judge, district attorney, and court personnel are not required to explain court procedures or the law.
God, she's had to do that
among
all
other
day
things,
long.
and that he is required to follow all legal rules and procedures that an attorney would have to follow in court.
Appoint him a lawyer.
He was also advised, and this is just one part of that form, that it may be difficult for him to present evidence. It may be difficult for him to do a good job as his own attorney. We discussed at length the advantages to having an attorney, the disadvantages to representing oneself. And what he is asking this court to do is to explain the law.
For the sake of
It
our
could also be
sanity,
described
appoint
as a
him
request for
Mhm.
legal
an attorney.
advice. All right, with that then, I'll certainly take up any arguments from the parties as it relates to both of these issues. I'll start first, though, with the motion to adjourn. Mr. Brooks is holding up the objection. That we're not taking testimony at this time, so the court does
can't
not feel
object right
compelled
now.
to acknowledge that any further, other than to say the fact that he's objecting is noted for the record.
Oh,
Mr.
Lord.
Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings. And as such, I will give you the first
boy.
opportunity to
Here we go.
talk about the evidence that I've heard here today by way of testimony, and to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion.
Good God.
All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
How much time does he get?
Well, I'm not arguing. I stated,
He's just going to
pretty
repeat everything we've already
why
heard.
It should be an adjournment. I don't think I need to argue anything. I don't think I need to provide anything more. If it's clear to me that the wrong person was testifying. She said that
Farron,
she was
I just
not
got the pictures of the
present
judge.
for
I know, right?
some of the tests.
Holy cow.
Total makeover.
To
When
her
did that
knowledge,
happen?
no way to
That was smart of her.
I think it was like 2016.
why I wasn't provided
So she knew she was going to be on camera.
with the test that I
Mhm.
should have been
Maybe.
provided.
Obviously.
That becomes an issue.
The judge had a makeover. We'll have to show you that picture in a second.
Honestly,
Here,
Your Honor,
I'll pull it up.
I'm powering my way through this hearing.
Oh,
I feel
find
like total
Farron.
crap, to be
What happened? Did the stream go dead?
honest with you.
Oh,
No.
okay.
I
It
don't
cut out
feel
for
good
me
at
for a
all.
second.
Um,
It's this
my
website. It has too many
reasoning
pop-ups.
for raising this issue, like I said, was strictly a health and safety thing. It didn't have anything to do with trial prep. It didn't have anything to do with access to anything. It was strictly because, like I stated before on record, I've never had this issue come up for me. Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease. Frankly, I'm terrified because I have
Okay.
So here's
to
a before and after of the judge.
get the results back.
Well, I guess
to say
after and
whether I'm
before.
positive or negative.
So somebody got a hold of her
And
and gave her a
that's-
voluminous hair makeover.
She got like a Brazilian blowout.
Yeah.
Tested positive for
Normally, I would say go with your curls, but she's got these
frankly,
waves that are a little
to even be told
messy.
Mm-hmm.
that it's a possibility.
I like the
that
blowout
could
better, and that's
have
unusual
COVID,
for me.
It makes me very afraid. Which is one of the reasons why.
Please show makeover pic. More
Yeah.
interesting than this dang droning.
Have to be essentially.
Let's see it again. We can
quarantined.
go, we can go over exactly what she did.
Isolated.
So she
Okay.
darkened her hair for
First thing I was
sure.
thinking about
Obviously
was
darkened it.
how would I be able to use the phone?
And
be able to
then
tell
the
my family
blowout
what's going
came
on?
with some extra
How
curls,
would
so
I
they
be
probably
able to
put a
reach
few
out to
extra
my
on the
kids
bottom.
and things like
She
that?
toned down her
Hey,
eyebrows.
I got
Yeah, her
health
eyebrows
issue
are
going
far
on
less
here
thick.
that I'm worried about. That was my
She
concern. And my
I
intention
think she
was
lightened up her makeup.
to at least
yeah,
be able to
and I think a lot of it is the lighting from the picture on the right, but also either she's
Yeah.
outlining outside of her upper lip or she got some upper lip injections.
That was
Oh, possibly.
like I said, I just
She
can't.
looks
And
great,
she might have gotten like Invisalign because her front teeth
Oh, I see that.
look more straight in the second
Mhm.
picture.
Although she's got a
Like I
wider
said, I can
smile in the
understand the
before
protocol
picture,
until
so
it's
maybe
explained
her
to me.
bottom lip is
So I was
covering up
just
the top teeth a little
coming into this knowledge
True.
in the
as well.
after.
Mm-hmm.
I'm still
She's a
trying to
cutie,
get my
though.
head around it.
Yeah, she's beautiful. Like I said, she reminds me of like a Monica
But
Lewinsky,
Your
but
Honor, that's
prettier.
pretty
Yeah.
much all I
Not
have
that
to say
that Monica Lewinsky's not pretty, but
strictly that.
Yeah, this judge is
And,
lovely.
you know,
Red one, thanks for the super chat.
not
What's
wanting
up,
to
Megan? Well,
if
what up?
I'm
I am
drinking,
positive,
and
not
Farron's
wanting
here,
to
which is such a
infect
coup. I'm so
anyone else
glad she
or
could come
put
by. I
anyone
gave her
else
like
in
15
jeopardy.
minutes notice.
Oh no,
And
I can usually
also
pop in
doing the
pretty
things
quick.
that I may need to do if I'm found to be positive.
Shawnette does
doing
have
the
a
things
pretty
that
name.
I need to
Shawnette
do.
is a beautiful name. It's
So
true.
that was my concern, and that's why
It's
I
very
raised the issue.
unusual. Show Daryl's makeover next. Okay, no problem.
Oh, okay.
Thank you, Mr. Brooks. I'm going to turn to the state.
Here's the
then.
before.
As a reminder, don't interrupt them. Thank you.
Here's the before, and you
Well,
know
Judge,
what he
I'm
looks
glad
like.
to hear
And
Mr.
here's
Brooks
the
say
after.
This is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still
I have to make a super quick phone
respond to
call.
his
I'll be
needs
right back.
properly.
Okay.
It's about my
if it's
apartment
merely a
in
health and
DC.
safety,
Oh boy.
I believe we easily overcome that, Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls just this morning alone. So his
Should I get
statement to the
Farron
court that he
to
was
do
worried about being
karaoke
able
with
to
me at
call
the
his
end of the
family,
stream?
I think really is
That would be funny.
questionable. I also would like the court just to acknowledge that document 258, and perhaps that's a moot issue at this point, but I still think a record should be made that no matter what circumstances have arisen with Mr. Brooks specifically in the confines of the Waukesha County Jail, he has always had access to his legal materials, the discovery in his cell, and the necessary tablet and computer so that he can prepare for his case.
This poor
So I would
prosecutor.
ask you to deny the motion to adjourn
She
because
really
of the
needs my
COVID
help.
protocol, and to the extent that there was a prior motion to adjourn
That
because
hair
of
is
a
not
keep
doing
separate order,
anything for her.
that also is inappropriate at this time.
I would
Thank you.
like to help out.
Thank you. I'm just pulling up a couple of documents so that I can review them electronically as I make a decision here today.
Look at him.
You may briefly respond. Go ahead.
Oh no, Ariane, you got a hornet stinging you today? Oh, I'm so sorry. This is going to sound crazy, but get a cigarette. Take the tobacco out of it, put it in your hand and get it wet and stick it on the sting and put a Band-Aid on it and let it dry like that. The pain will be reduced by a lot. Old Jamaican trick I learned from my Jamaican grandmother.
I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk. I don't see where there's...
It stung you on the boob? Oh, that's bad. Do the tobacco trick. I swear to God it works. I swear. We'll take the swelling and the pain right away. Oh, good.
This morning,
I think we should close out this stream, Farron, with some karaoke. That's what I think. I've been told you do karaoke.
I have before, yes.
But
But I will say I did wake up. I didn't do a local stream this morning because my throat was kind of sore. Because it's the changing weather and all that.
Yeah.
So yeah,
it's bad for allergies right now.
Mm-hmm.
You and I are going to have to talk about locals later. I feel like I bore everyone with my locals problems, but I have nothing but problems with locals.
Really?
Yeah, I can't make it work properly. And I don't know. I think it's me.
The
Nick
court has heard
like
from Mr. Brooks. The
hooked me
court
up with
has
this locals
heard from
person and
the
they
jail
can't figure it out either. So it must be
administrator.
me.
The DA is
I'm a
providing
moron.
additional information as officer of the court. Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication form earlier today, raising this issue. He is on a protocol. He is not tested positive.
Thanks,
He
PD. I'm
provided
sure she
information
appreciates
today that he is fully vaccinated.
the
That
offer.
he'd been telling officers for days that he
One
had
of our
not been
chat
feeling well.
members got
We do not
stung by
have
a
the test
hornet
results
on her
today.
boob while she was listening to this.
He
Oh,
Can you
God.
imagine the
was
pain
offered a
on your
rapid
boob?
test and
I blame
refused.
Daryl
Hornet sting?
Brooks.
He reports symptoms of fatigue and that he can't taste. He also indicated it was a few days ago over the weekend that he started experiencing these symptoms.
The
Now,
fact that
during
he's
his
been able to
time
sit
here
here for several
today,
hours
Mr. Brooks,
should be a done deal.
Despite the disruptions, has been very clear, coherent. He
Oh,
has
no.
asked questions.
She's
He's
not going to
made
give him a
objections.
lawyer.
I know he might not like the word argument, but that's a word that we use in the adversarial system when the court asks the parties for their positions on certain issues. We call it legal arguments.
I wouldn't
or
call him
arguments
clear.
For short. Doesn't mean or have any connotation that it's unruly or disruptive or a disagreement. It's just the word that we use in the legal system. He was able to articulate his positions to the
I
court.
disagree.
He at times appeared
Thanks, Red One.
animated. He
I got stung
appeared,
by a bee, says Amber
again, to
Heard
understand
facial.
what the court's either
Stung by a
questions
bee?
that the court was posing to him or information the court was providing to him. He clearly was able to.
You cannot
Mr.
object to the
Brooks, please
judge
don't interrupt me,
speaking.
or I will mute you.
Oh my
He
God.
was able to follow the questioning and answering process with the one witness who was here today. I appreciate that he clarified that he was not making this request due to trial prep or access to material issues, but it was really related to his health and safety concerns. At this point, there's insufficient information on the record to find that his concerns are anything more than speculative. And given my observations here in court today, he is very ably or very able to assist in his own defense. He's able to present arguments, etc. I've already noted. We are able to accommodate the health and safety concerns in this courtroom. We confirmed that where he sits at the table, if he's in this courtroom, there is no one around him who would be within 6 feet. That is an important consideration that has been one of the
B emojis
topics of guidance
there's
from
just a
the
plethora
CDC,
of them now.
certainly one of the or part of the guidance we have received from the county. The most recent county protocol talks about isolation for 5 days. Clearly, if he had the onset of symptoms over the weekend, which is what he reported, and he has not had any escalation in those symptoms, as has been demonstrated by his ability to participate in this hearing. The court will find that there are no present health and safety concerns other than what I've noted with the 6 feet.
If this judge has a husband or a boyfriend,
I'm not
they
going
need to be ready to give
adjourn
her a
this
foot rub
trial.
when she gets home after
Exactly.
Also put on the record that he has not been denied access to materials. He has full access even with this.
I'm not
protocol.
usually
He
empathetic
has
towards judges,
had
but this
access
one
even
has
to the
got my
phone.
full
There's been,
sympathy.
what's been referenced by both the state and Mr. Brooks about attempted phone calls.
She's
I'm not
far
so
more
concerned about
patient
whether
than
phone
I.
calls go through.
The
It's
chat
fact that he's been
is
given
offering to give
access.
her that
Whether
foot
he
rub.
connects with someone is not
Yeah.
the issue.
PD,
I'm
I also
concerned
volunteer.
about the fact that he would not answer the court's question directly. about
Kamala, I
whether
don't
he
think
would
you can
take a
be in
rapid
this chat
test.
if you don't like
To
feet.
me,
We've
his
got all kinds of foot
credibility is at
fetishists
issue with
here.
that. If he were truly
What
concerned
is with
about
the
his
foot
own health and
fetishes?
safety, he would want to know immediately. And he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not.
Yeah.
All right, you're interrupting me. I'm
God.
going to mute you.
Oh,
Goodbye.
man.
So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic.
Yep, delay
given the
tactic.
information that this court.
Good call, Judge.
And once again, on the record before me, there is nothing to suggest that he
Can't
is
stand trial.
actively being impacted
Move it along.
by COVID-19, and that any health and safety concerns he has for his own safety can, again, be met. The jail's able to get him here.
That would be
The jail, of
hilarious,
course,
Shawnette.
is responsible
Just
for
holding
his
up signs
medical
to your
care.
husband.
We can keep him 6 feet away from any other person. Obviously, if he's removed to the other courtroom, that provides a greater buffer as well. And for all of those reasons, I'll deny the request to adjourn.
Good.
As to the issue that was
Finally.
raised in the inmate communication, obviously this was a form that was sent by Mr. Brooks on Wednesday, September 28th of 2022. That was the day on which this court granted his request to represent himself. We know from the record, not only from today, but previously, that on September 28th of 2022, what he would have had in his cell would have been materials previously provided to him by his attorneys. His attorneys, through Attorney Perry, dropped off 3 bankers' boxes worth of materials and a flash drive to the jail later that date. And the jail followed whatever protocols they have with regard to those materials and reviewing them, and that those materials were provided to Mr. Brooks on September 29 of 2022. He's confirmed through the most recent request to adjourn that he
she has a
wasn't
very
even
pleasant
making that
voice.
request based on
Listening
any
to
type
her
of
won't be too
access
much trouble.
limitation to materials or things
I
of that
liked
nature.
Penny
although
Ascarati
not a
too in the
specific
Johnny
statement
Depp
by
trial. I
him,
thought she was great.
this
Yeah,
court
she
would
had a
take
soothing
that to
voice.
mean he has
And
been
she was
able
like
to
so
continue with
rational
his
and reasonable.
preparations.
And
I'd
she
also
never
put
got
on the
upset.
record
She was
that,
just like
there's no doubt that being
very
in
objective.
trial can be exhausting. We, of course, had 2 afternoons of hearings last week. Of course, he was provided with a lot of material. From my perspective, he clearly understood the perils of self-representation and the volumes of
Penny
material
was
that
great.
he would need to
I
review
agree.
perhaps a second time because he had some of them, or for the first time. Those were things that were clearly he was clearly advised of before I granted that
He's
request.
still at it.
And then, of course, we
God.
had 2
Like,
very long
Sir.
days of jury selection.
We got to stop.
Yesterday and the day before. Given the way this jury selection progressed, we did not start with court until today at 1:30. Frankly, part of that was done not just to provide access to the media pool and the cameras and other things that needed to be installed, but honestly, to provide a little bit of a break for myself, and I would hope for the other parties as well. Of course, everyone continued on with their preparation, but I actually understood this request. I may not have referenced it previously, but that really factored into my decision to start later today as well, and to not bring the jurors in until tomorrow. So I am satisfied that Mr. Brooks has access to his materials that he needs to prepare for trial. As I indicated
too.
earlier, I have also provided
Satisfied.
to him the Wisconsin Criminal Code and selected traffic statutes, including the
I
Wisconsin
wish she would
Rules of
appoint him an
Evidence.
attorney.
It's from 2018. While there might be
She
some slight
kind of
modifications
does look
to
like
some of the
Jodi Arias, but
substantive
Jodi Arias was not
statutes,
as pretty as her.
this would give Mr. Brooks
She
a
has
very good
something of
reading as it relates
Jodi.
to the rules of evidence and the statutes that relate to the charges he is facing. I'll provide a copy of that, a photocopy of the cover, so that it's docketed in the
I remember
case
that.
as well.
Your mic is off, Miss
While this
Breedoff.
court is under no
Yeah.
obligation to do that,
Good
since
times,
I was able
man.
to
Good
locate that,
times.
I am putting that on loan to Mr. Brooks. What he also needs to understand, though, that at this point it is for use in the courtroom. I would entertain a request that it go back with him to his room on a couple of conditions.
Red one.
One, it
Thanks
would
for the
be
super
that
chat.
he
I object,
agrees
Your
to
Honor.
bring it
I
to
would like
court each
access to my
day.
SUV and rap
Two,
CDs
that
to
it
better
be
represent
maintained in its
myself.
current
This is
condition.
abuse,
And then
Judge.
three, that
Denied.
it's returned at
Brooks,
the
I don't
conclusion of the trial.
consent.
So that will be for
Yeah.
him to decide how
PD
he
wants to know, is
do
she a
that.
wood for you?
He has
The judge.
been raising the sign objection
Yeah.
at all times
Probably.
during my oral decision. I would
But I
note
don't like girls.
the
But if I
use of an
did, she would
objection
be a wood.
is when the trial is in an evidentiary phase
Same.
or a motion
very
where
pretty.
we're talking and addressing the receipt of testimony and evidence. It's a mechanism under the law by which a party objects. They usually state either a 1 or 2 word basis. Sometimes it might be a short sentence or 2. Sometimes the other party's given an opportunity to respond if it's self-evident to the court as to either what the objection is or the basis for a granting or denial. But the court rules on it, and then the parties move on. Those are the
No.
not
You don't
only
get that
expected
kind of
procedures
detail.
for this
Not without
case,
serious super
it
chats.
also comports with just the tenets of and respect that you don't interrupt. Again, an objection is a legal basis to interrupt, but it's
Yes,
done
she
in
can
a
join
way
the
that's
pool fight.
respectful. Simply holding up a sign that says objection is not
Look at him.
does not comport with those expectations or procedures. All right, so
What
I've
an idiot.
addressed those 2 issues. I have a list. I'll tell the parties what's on my list, and then you can add to that as well. I do know the state filed a motion for reconsideration, so that's on my list as well. I wanted to touch base on the request for an interpreter. Again, the motion for reconsideration. I've already addressed the subpoenas. Madam Clerk, can you just confirm for me that they were signed by the clerk's office and then the 10 copies were provided to Mr. Brooks?
Correct, while he was sitting here.
While he was seated in the courtroom. At 11:18 this morning, he was also provided with copies of subpoenas. Do you know how many copies were provided?
21 this morning.
21 this morning, an additional 10, I believe, this afternoon. So he has those available for his use. I've already addressed the statute book, so I can cross that off my list. And then, of course, preliminary jury instructions. Now, I know Mr.
Yeah,
Brooks,
I don't know,
think, did
Noel.
not bring his
What
with.
would the interpreter
I
be
wanted
for?
to make
No
a
idea.
change to those before
He
I
seems
printed
to speak
off
English.
a copy for him.
Shawnette, for
It's
stupidity.
not a huge change. It's really just an addition. And it has to do with some of the language that I have
All right.
been.
This is a lot of housekeeping. I'm going to mute it because I don't want Farron to have to go without saying a proper goodbye. And no one really cares what this woman, what the judge is saying right now.
Mhm.
She's ruled against him. The trial will go forward. This was just a pretrial hearing.
Sorry, bro.
Sorry, bro. You lose. But Farron, you have apartment stuff to deal with. Are you moving? What are you doing?
Yeah, I'm moving back to DC.
Oh, I didn't know you were out of DC, so I haven't caught up.
I moved out of DC in July because I was like, hey, there's nothing going on here. And then sure as shit, 2 months later, I get a call and they're like, yep, we're gonna send you back. And I was like, okay.
Oh no.
So we're going back.
Oh my goodness.
Excited, sort of. But either way, it'll be fun. But yeah, it's just dealing with all the apartment crap because they're calling because like, we need your insurance, we need this. And I'm just like, oh my God.
Where did you move when you left DC?
Oh, to Chicago, just back home.
Shut up, my town. You moved to my hometown. Holy cow! Where do you live in the city in Chicago?
No. I'm just at home with my parents for now. Just for like, I've only been home for like 2 months. I haven't been home since I was 18.
Are they suburbs people?
They're suburbs people.
I grew up in Palos Hills and then Palos Park, and then I lived in Mokina for a long time out in.
Oh, very
County.
cool. Okay, yeah, I'm DuPage County.
DuPage, gotcha.
Yeah.
Oh, lots of corruption out there in DuPage County.
Oh God,
lots and lots of stuff going on there.
Oh yeah.
Yeah, so DC. So that's interesting because if you're going to be in DC, I'll be able to see you more often because my sister lives out there and I travel that way. She lives in Annapolis. I travel that way.
Oh, very cool.
Often. So next time I come, I'm going to have to give you a call so that we can hang out.
Yeah.
We can actually, maybe we can go do karaoke. We'll actually go to
for sure. We'll go to Chinatown.
That'd be fun.
Oh yeah. I love it.
Chinatown's the best. Oh my gosh.
I love where they're like Farron lives and stays in her parents' basement. No, that's where my studio was. And then I moved it upstairs because of the reception. But yeah, no, I haven't been home since I was like 18 years old. Like right when I graduated college, I went straight into news.
So, are you from Illinois? Is that where you're from?
From Chicago, born and raised.
That is so bizarre. Me too.
And
but you're younger than me. You must be younger than me. I'm
34.
Yeah, you're a lot younger than me. But where did you go to high school?
I went to a little Catholic high school called Montini Catholic High School in Lombard.
Okay. All right.
Catholic school kid.
Yeah. You probably know well, maybe you don't because you're so much younger, but what's her name? Jenny McCarthy went to Mother Macaulay.
My older sister went to Mother Macaulay.
Did she?
And my two older brothers went to Brother Rice. And then my younger sister and I went to Montini together. And then my youngest brother went to Nazareth, where Julian Love went. There's like a number of like football players coming from Nazareth now. So
Brother Rice there was a priest there who was famous for boxing. He used to let the boys box it out in the ring when they would get into fights. He would put them in the ring and put gloves on them and make them fight. if there were any fights in the halls. I remember hearing about this when I was a kid. We used to hang out with, I went to public school and private school, but we used to hang
Mhm.
out with like the Catholic school kids from Macaulay and Brother Rice and
Mhm.
stuff. So I would hear these stories. That's funny. I didn't know you were from Chicago. So that's
Yeah.
interesting. We
Wait,
have
what high
that
school
in
did you go
common.
to?
Stag. I
Oh,
went
you
to
went to
Chicago.
Stag.
I went
Okay.
to Chicago Christian High and then Stag.
Okay. When I was on the dance team at Montini, we always had one of our dance competitions was at Stag,
Mhm.
every single year. So
That's funny. I was on the dance team for a very short time at Stag, but I'm like more than 10 years older than you. I'm 40. I don't even remember how old I am. I think I'm turning 47, but I'm not sure. I'm going to have to check. Yes,
ballpark
because
it. Yeah.
because my daughter is turning 17, which means I'm turning 47. But I've lost after 45, I've lost total track.
I know, right?
No
You have to
idea.
actually use the calculator to be like, "Oh, yeah,
I
that's
know.
yeah,
What year was
mhm."
I born?
Yeah.
It's
I
so
feel ya.
crazy.
I'm already at that, like, in my 30s. I'm like, I don't even remember at this point. But yeah. Mhm.
Well, that's I did not know you were from Chicago. That's fun.
Yeah. Mhm.
We probably have a lot of, similar stories,
Oh god, yeah.
growing up there and,
Yeah.
hitting the downtown clubs when we shouldn't have been. Uh,
Same,
Same.
same.
Did you ever get a fake ID from the flea market in Indiana? Did you know
No, so
about
I
this?
went to college in Indiana.
Did
So we
you?
already they yeah, we didn't need the flea market. They were doing it at Purdue.
Well, yeah, you went to Purdue?
Yeah, I went to Purdue, yeah.
Oh, that's
Mhm.
funny. So my first boyfriend was at Purdue. That's where I met him. So I used to drive down there all the time from Chicago. That
Mhm.
3-hour drive down the middle of Illinois.
Mhm.
Purdue was a fun campus. Oh my gosh, I had no idea we were so
Yeah.
similar. That's
I'm
so
a
funny.
Midwest kid. Yeah, Midwest is best. Mhm.
Well, I will let you go. You've got stuff to do for your new apartment. Thanks for hanging out with me today. My
We're gonna have
God.
to do it again. We're gonna
You
have
were
to do it
like,
again.
I can do it for 30 minutes. You've been here
Yeah.
for 2.5
I
hours.
know,
Good
right?
for
I'm
you.
like, "Daryl, I got shit to do."
I know. Move it along, Daryl. But
Exactly.
if you guys are not subscribed to Fair and Balanced YouTube channel, I will drop it in the whatever the chat. I'll drop it in
Yeah,
the
yeah.
chat, and also I'll stick it in the description for you guys as well. But you should be subscribed over there to Fair, and she's fantastic. We love Fair and Balanced, so
Oh,
get
and we
over
all love
there.
you too.
Well, it's been a good time. I'll tell you
Yeah,
what,
definitely has.
been a
But,
good time.
well, we'll get together soon, I promise.
All right, you take care.
Thanks so much for having me.
Alrighty, bye bye. Love Farron. Absolutely love her. And no, we probably will not be fighting anytime soon. I can't imagine anything we would disagree on so far. Okay, so he's holding his head. Do we have sound? What's going on with the
I have an
sound?
added
There
topic
we go.
related to court TV exhibits and FCC rules, and just some things that may be
I'm gonna drop
impacted
her channel
during
here.
the broadcasting of the proceedings because of the FCC rules, which I will claim I'm not an expert on, but I felt compelled to at least tell the parties. I'll start with that so I don't
All
forget.
right, dropping
And
in the
that is
chat.
I have been
Get
advised
over
that there
there
are
and
FCC
subscribe to Fair and
rules that may
Balanced on
require
YouTube.
graphic
And
images or
Facebook is not
videos to
letting me do
not
this.
be broadcast. And I know the state at one point had made a request, and we had talked a little bit about individuals
Thank
who
you,
might
Red One, for the super
who
chat.
are victims appearing in a remote location and watching the live stream and seeing those exhibits. And originally, I had planned to utilize Zoom, and there's a share screen option. I'm not going to be utilizing the Zoom because of now the new mechanics for the live stream and the pool feed that Court TV has taken over and is providing to all of the other media that wants access to it. So I just wanted to make you aware of that.
Thank you, Judge. And I believe there was a workaround that was accomplished with the cooperation of Court TV and the county IT so that the victims will be able to view whatever is being shown in the courtroom, notwithstanding what's broadcast to the general public under FCC rules.
Excellent. I'm glad to hear that.
Yeah, and I would like to know for the record that the Court TV was very accommodating and very helpful in that regard, and we appreciate that.
And as a reminder, so you'll see there are some cameras that have been installed in this courtroom and some microphones. Like I have an additional microphone next to me. There's a camera down in front of the court reporter. There's a camera in the back, and there's a camera over to my left in the clerk station work area. I've also indicated, because now we may have to use the adjoining courtroom, they're in the process of getting some equipment so that there's a camera in there as well. I know that needs to be worked through with the county facilities because of the cabling and all of that. So I just wanted the parties to be aware. I have approved of all of that. That brings me to a related topic, and that's the use of the courtroom microphones are still an audio backup, but we have really good microphones in this courtroom. The state noted it yesterday, or maybe it was the day before. At one point, Mr. Brooks appeared to be muting the microphone in front of him, but because there's microphones elsewhere, we were still able to see the audio. I'd advise the state of the same thing. You have microphones behind you through the court system that just because you mute the one in front of you, you may
Farron
still be
had to
picked
go.
up.
She's taking care of her
and
moving
that just
stuff.
whispering
She's
still
moving back
comes
to
through
DC.
on the microphones, whether they're the courts or otherwise. So,
Can I ask a question about that, please?
sure.
During recesses, is it possible to mute all microphones so we can confer?
Absolutely.
Okay.
Remind me,
Sure.
right? We need the clerk to do that. But I think if we all cooperate together, we will get that done.
Thank you.
All right. Any questions about the broadcast, Mr. Brooks?
Oh God, don't ask him. Please don't ask him.
So, I'll go with the part that I don't think that if you are not in the courtroom, that you should be privileged to
What?
see anything. I think the word you used was graphic.
Yeah, it's graphic, Daryl. You ran people
I am not
over.
responsible for Court TV's compliance with
Holy
FCC
shit.
regulations, but it's my understanding
Oh,
that
God.
they will meticulously follow whatever the regulations are. But what's in the courtroom is clearly going to be what's in the courtroom, and anyone in the courtroom will be able to see fully based upon the monitors, including the jury, including the court, and including you, whether you're in this courtroom or the next courtroom.
Yeah, that would be the preference. If you're not in court, you shouldn't be able to see everything in court.
All right, moving on to the next topic then. There's a state's request for an interpreter. I wanted to address that because the form that you used, and thank you so much for doing that, requires that I sign an order. But it's my understanding that
Yes,
that
Laura,
request
he's
may be
alone and
modified.
wearing a mask.
Yes, Your Honor. As to the timing, certainly it will be modified because I think I indicated October 6th or 7th. I no longer anticipate that being necessary. It would likely be one day next week. If you give me just a second here, I can maybe give you a better idea. I'm wondering if the court, I hate for the court to pay for an interpreter that we don't use. So I don't know how much notice you need to give to the interpreter or how far in advance you have to reserve them before you have to pay them no matter what. I don't know if they have rules like that or not.
They do.
Okay.
It depends.
Okay.
So thankfully we have one local interpreter who is incredibly reasonable and I know is kind of on notice, but it really depends on his schedule. And what we may have to do as the courts, because you are correct, it's the court's responsibility to do this, to pay for it. I will not make arrangements just yet unless just based on the request that was made, because you said it's no longer a date that
Maybe
you would
they
target
needed
for
an interpreter for
that
the victims'
interpreter.
families.
I'll decline
Oh,
the
Shawnette, no, he killed a lot of
proposed
people.
order.
There,
And
a
then
lot of
just
people
if you want to
died. He's being
resubmit,
charged with 6
course, we have
counts
someone
of
in the clerk's
intentional
office
homicide.
who
There
is
might be others. I'm not sure. I need
parties
to look it up.
work
But
with
he
regularity
killed and
to
injured
obtain
many
interpreters, and
people.
so
He ran over
the state can
children
simply
and
continue to work
grandmothers
directly with
with
that
his
person
car
to
at a Christmas
facilitate and
parade.
hopefully keep the costs down.
This man is a monster, and he's being allowed to just
we'll
make a
deal
mockery
with
out of this system that
whatever
we have.
the fallout financially. Typically, we need 2 business days to cancel them.
And the only reason
so
why
if
I'm
you
laughing
can
at
make
it is
arrangements,
because
for example,
otherwise,
say next
what would
Thursday
we be
or
doing?
Friday for those witnesses to appear, and then you decide you don't
It's
need
too
those
horrific to
witnesses,
contemplate.
and we should be able to cancel them by Tuesday or Wednesday, depending on the day that we've selected.
But something that was
Sure, I
suppressed
understand.
from
That's very
the
helpful, and we will definitely be diligent
from the
to
media was that
keep
he
the
was
court
also
informed. I understand.
a
I agree.
militant
It's appropriate for the court
Black
to
power sort
deny
of
my request
person.
today, and I will renew it.
And
as needed.
it's interesting that
You
he
know,
ran
as I
over a
think
parade
about
full of
that,
white people.
I think what
But
I'll
nobody
do
wants to talk
is
about
I'll
that.
approve it, but I can put some. I should
Hopefully
be
the
able
state
to
will
add
bring
some
it up
language about
because I think it was intentional.
this date may be modified through direct communication between the DA and the clerk's.
All right, I'm so
The
bored.
person in the clerk's office responsible.
so
I
bored.
don't need you to file again and again if it's
I
really
don't
the
think that
same
this
request.
is-
It's just the date is changing, and you're doing that
All right,
in order
listen.
to.
No one's going to be, upset if I cut this off, right? Like, this is just like calendar stuff. I can't with this. So can we, killed 6, injured more than 60. Thank you for the information, little galaxy. Before I go, I want to show you, maybe we'll end on a hilarious note instead of this horror that we've been watching. But my newest article on PJ Media is about Taylor Lorenz, and I kind of got into this with Farron earlier. Clickety click, I'm putting the link in the chat room for you guys to check out my latest article on Taylor Lorenz. Severely immunocompromised journalist Taylor Lorenz unmasked. Taylor Lorenz, tech journalist, which really means gossip columnist, at the Washington Post, is confusing all of us. Just a few days ago, our sister site Twitchy reported Lorenz's deep fear of going outside with her N95 due to what she said is a condition that has left her severely immunocompromised. This condition gives Lorenz permission to berate whoever she wants for not wearing masks in public or something. Replying to a doctor who took a maskless selfie at some event, Lorenz replied, "As someone who's severely immunocompromised, this is absolutely horrifying and disappointing to see. A stark reminder of all the medical professionals who don't care at all about keeping vulnerable patients safe from a raging, deadly, and disabling pandemic." Yeah, she really said that to this poor guy who just took a selfie at some event. Like on October 1st, the pandemic's over. Twitchy roasted her good for this. They said Taylor Lorenz has smeared and doxed people, literally leaving them vulnerable to injury or even death, like Chaya Raichik, libs of TikTok, by the way. Keep that in mind as she complains about people who aren't anywhere near her not wearing masks, leaving her vulnerable to further disability or even death. While Taylor's busy complaining about doctors, most, if not all, of whom are likely vaccinated, not wearing masks, she should seriously consider wearing a muzzle. Maybe 2, just to be safe. I love Twitchy. So funny. But it gets worse. Lorenz is being cast in documentaries and TV shows as a brave journalist and is having quite the moment in Hollywood right now. She stupidly posted behind-the-scenes photos on her Instagram just days after this tweet, you guys, showing very clearly that she's on the set unmasked while security and other help are masked. Apparently, Lorenz only wants people to wear masks for her, but she's not under any obligation to, how did she put it? Care at all about keeping vulnerable patients safe from a raging, deadly, and disabling pandemic. Do what I say, not what I do, peasants. Look at this. I mean, you've got to be kidding me. This woman is unbelievable. That poor security guy, he looks so miserable. It's a stark reminder that there is a class system in America, the elite, like Lorenz, and everyone else who have to wait on her. Oh my good, look at this poor guy's face. Like, this is someone who's given up on life. But thanks to the internet, the jokes keep on flowing, and someone started a GoFundMe to help Taylor Lorenz lead a normal life. LOL. Seriously, look at this GoFundMe. World-renowned investigative journalist Taylor Lorenz is the picture of beauty on the outside, but her trademark flowing silky hair and pearly white smile betray her profound struggle against Mother Nature, severe crippling immunosuppression of idiopathic origin. Severely immunocompromised, Taylor is unable to live life as we do. She cannot venture into public, ride the subway, or go to the grocery store. Meetings and presentations are an ongoing terror as the general public grows disconcertingly complacent with masking, thus putting her continued health and emotional well-being under relentless assault. Her immune system is simply incapable of fighting off common infectious diseases caused by coronaviruses, organisms that are cruelly endemic to our natural environment. This fundraiser is to raise money to help Taylor live a safe and happy life with lab-grade sterile N95 masks, 24/7, 365 car service in a vehicle equipped with high-flow HEPA filtration, private jet travel under the care of fully vaccinated crew and registered nurse, access to top doctors and researchers in the U.S. and abroad. Just remember, folks, no matter how bad you think you have it, Taylor Lorenz has it worse. Stay tuned for another sit-down interview with Lorenz, where she can cry on camera and claim that she's being bullied because she's a woman instead of an insufferable hack who doxes people for a living.
You feel like any little piece of information that gets out on you will be used by the worst people on the internet to destroy your life. And it's so isolating.
And terrifying.
It's horrifying. I'm so sorry. It's overwhelming.
I'm so sorry.
It's really hard.
Oh my God. Like, you guys, seriously, how does this woman survive? All right, you did miss Farron. Farron was here for 2.5 hours, and she had to go. But you can back up and watch the whole stream with Farron in it, and she is wonderful. So make sure that you go and you check out Farron Balanced channel and make sure that you subscribe. Now, also, there is news. Last week, you guys were probably here for my Oklahoma stream where we called out Oklahoma lawmakers who are Republicans for not stopping gender experiments on kids in their state. I put this up yesterday. The Oklahoma governor has now called for a statewide ban on medical gender experiments on minors, which is great. And you guys should go and read this. I'm going to drop this in the chat, and then I have to go because I have got to go get dinner ready. And apparently we're out of chicken. So I don't know what we're going to do being out of chicken. So clickety-click on this article so you can catch up on what is happening. And I will see you guys again soon. I don't know when the mood strikes. I don't know. If this trial starts tomorrow, I will probably do this again because this shit show cannot be missed. So now I have to go scramble for dinner. I don't know what I'm going to make. I'll figure it out though. All right, everybody. Take care. Thanks for being here.